calling this meeting of the Cannabis Control Commission to order as of 1:02 p.m. I guess it is on the 9th. August 9th, 2018. Do I have the date right? Thank you. Can I ask? Can everybody hear me in the back? Thank you. Can I ask? Is this meeting being recorded? Let me public. I notice that the meeting is being recorded. Can I ask everybody please to take their cell phones and put them on mute or shut them off? Okay, thank you. That includes the commission and the executive director and staff. Okay, thanks. We have a pretty full agenda. I don't really have any comments other than let's get into the agenda. Starting with, we have 2 sets of minutes to be approved. I know there's some edits that have been proposed those minutes, so we'll discuss those 2 sets of minutes. The executive director report, as usual, will include. We have a new team member. Oh, there you are. Okay, so we're going to introduce a new team member and other staffing. We'll go through the statistics that we have for license applications as of last night, and then there are a number of issues that require discussion and in some cases votes. Starting with guidance for farmers that Commissioner Doyle has taken the lead on. So thank you for that, Commissioner Doyle. Second, the executive director is going to make some recommendations with respect to waivers for marijuana establishment agent registration in terms of background checks. So he will cover that and make a recommendation. We are launching the public awareness campaign that is required under our legislation. I wanted to first of all thank Commissioner Flanagan, who has been the driving force behind this. There's been a lot of staff involved, and I'm going to let Commissioner Flanagan recognize all the staff has been involved, because it has been extensive, but it's a pretty big milestone, very important part of our mission, and we are going to release that today based upon the conversation we're going to have. There will be a presentation that both Commissioner Flanagan and our Director of Communications, Cedric Sinclair, will go through to describe the campaign, how we got to the messaging, and how we're going to communicate the messaging in the campaign. So that's an important agenda item. There were 2 discussions at our last meeting 2 weeks ago that we agreed to defer final vote on to open to public comment. We received a fair number of comments, which I'll describe the amount that we got, and we agreed that we would reconvene on those 2 topics today and discuss and vote on them. So that's both the general guidance to communities with respect to host community agreements, as well as the equity-focused municipal guidance document. So for all of you that did make oral or written comments, thank you very much for your input, and we'll discuss modifications of any of those documents based upon the feedback we got. So those are the 5 discussion topics for the agenda, and then I think, as everybody's aware, there are 7 license applications that the staff will make recommendations to the commission on, and we will discuss and vote on. And I think between the 5 discussion items and the 7 applications, we're going to have a pretty full agenda today. So with that, let me move into the first agenda item, which is minutes from previous meetings to review and vote on and approve. Somehow, I thought we were completely caught up. I don't know how this happened, and I'll take ownership and responsibility for it, but somehow April 18th never got covered by the commission and voted on. So the first agenda item is to discuss the minutes from April 18th, 2018. Has everyone in the commission had a chance to review the minutes? Are there any questions or comments on those minutes? Commissioner McBride?
I have an amendment made to July 26th.
Okay, well, let's start with the 18th first. And then, are there any comments on the or questions on the 18th of April? Then can I have a motion to approve those minutes?
So moved. Second.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Let the record show the commission unanimously approved the minutes from April 18th, 2018. So now we really are caught up. The second set of minutes are from July 26, 2018. I'll start with Commissioner McBride. Your comments or questions?
I just have an amendment or an edit to the 3rd paragraph, the 3rd full paragraph on the 2nd page, the last sentence, which begins the host community agreement.
I'm sorry, would you just do that reference again, please, Commissioner McBride?
2nd page, 3rd paragraph, the big paragraph in the middle.
Thank you.
And the final sentence. I would edit it. I went back and actually looked at, with the help and advice of my team, our YouTube page and rewatched this part of the.
Thank you for whoever posted that.
No, we posted.
Oh, we posted it. Thank you.
So the final sentence should say information about the costs associated with the host community agreement should be submitted during the renewal process.
Okay. Any comments on that? Any other suggested edits or questions?
I have a minor edit.
Can you make reference to it?
On the second to last page, the commissioner title asks if the commission could provide the new positive impact guidance.
I'm sorry, hold on a second, please.
This is the second to last page.
Yeah. Yeah, I did, okay, thank you.
And so, my edit is just to change that to commissioner title asks if the commission would review licensees' actions taken relative to their submitted positive impact plans during the renewal process.
Any concerns, questions about that? Okay. Any other suggested edits? Then can I have a motion to approve minutes as amended by both Commissioner McBride and Commissioner Tittle?
So moved.
Second, please. Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Okay, let the record show that the minutes were approved as amended by Commissioner Tittle and Commissioner McBride. Thank you. Okay, I think we're officially caught up. I hope that at a subsequent meeting I'm not going to have to undo that statement by looking at minutes from sometime in 2017, but I think we're good. So thank you to the staff for doing this. I know this is onerous and painstaking work, and so I appreciate the role in keeping us current. So thank you very much. Next on the agenda is the Executive Director's Report, starting, as I mentioned, with the introduction of a new staff member. So let me go back. Good. Mr. Executive Director.
Thank you, Mr. Chairman. As you indicated, we do have a new team member I'd like to introduce. This will become a recurring theme as it has been for some time as we continue to build our staff. The individual is Patrick B.A. Patrick joins the commission as our Director of Investigations. Most recently, he actually served as a New York State Police trooper. Most recently, again, as a senior investigator of the Middletown, New York office. So he comes to the commission with...
Oh, I have a history in Middletown, New York. I'll talk to you about it offline.
He probably already knows about it. That said, as our Director of Investigations, Patrick joins Yao Jibi's team, our Chief of Investigation Enforcement, and he will begin to develop or build up that investigative unit for the department, for the agency. So very excited to have him, very excited to have his contributions, and someone with his breadth of experience and expertise that he's going to really add value as we build out that unit. So excited to have him, excited to welcome him. This was his first week, this is his first week, so he's really getting his feet under him and settling in. So happy to introduce him.
Well, welcome, Patrick. It's been great to have you on board. Any other staffing issues, Mr. Executive Director?
Not at this time, no.
Okay, then if we can go through the summary statistics for applications.
So the usual slides, run through them, which is we have 2,264 total applications. Of those, 219 are pending with at least one packet having been submitted to the commission. 112 have been withdrawn. 1,921 remain incomplete. And of course, the commission has issued 12 provisional licenses to date. Those break down into 2 craft cooperatives, craft and water cooperatives, 4 independent testing lab, 2 laboratory agents, 45 cultivation, 65 establishment agents, 9 micro business, 26 product manufacturing, 3 research facility, 54 retail, 3 transportation with an existing establishment license, and finally 6 third-party transport. That is the 219. The next slide indicates those that are pending with 4 packets having been submitted. That total this week is 95. Breaks down to the following, which is 2 independent testing lab, 33 cultivation, 3 micro business, 24 product manufacturing, 3 research facilities, 28 retail, and 2 transportation with an existing establishment license. Again, on the right-hand side, in the right-hand column, you see the difference between the last meeting announced that is 10 additional licenses or 10 additional applications that are pending. The breakdowns are 62 R&D priority, 3 economic empowerment priority, and 30 general applicants. Those 95 break down to be 52 separate entities. The slide is becoming familiar is where those 95 stand as far as their review. There are 20 that have not been reviewed by the commission staff as of yet. 38 have been reviewed and deemed to be incomplete or requiring additional information. 18 are out for third-party interaction. That is, as you will know, the municipality interaction as far as certifying that they are compliant with all local ordinances and bylaws, and also our background check vendor. There are 7 that are pending before the commission today for review and subsequent vote. And of course, 12 have been considered and issued 12 provisional licenses. That's a total of 95. So as you'll note, we've been through the majority of applications in some way. And we're also into reviewing general applications now as far as the priority status. So folks that did not secure priority status through that certification process, we're now getting into the review of those applications and actually generating third-party notices out. So I'm confident that in the next few meetings we'll be able to bring those applications for your consideration as well.
But anybody that did get priority certification, once they submit all 4 packets and they're deemed complete, will come to the front of the approval or the review queue.
That's the case, true. And anyone that has been deemed incomplete and we've reviewed and said they require additional information, once they resubmit, they would return to their priority status.
Okay, great. Thanks. Any questions so far?
Yes. I've gotten many questions about labs. I was wondering if you could give an update about the lab applications we've received and where they are in the process.
Sure. So we did, as I indicated on previous slides, there are 2 that are pending with all 4 packets having been submitted. I'm, I guess, pleased to say that both of those applications were submitted prior to the Commission's August 1st deadline to secure priority review from the staff, and they remain a priority review of ours. For many of them, or for the 2 of them, the review, of course, starts with a completion or completeness review. If complete and both have fit within the complete categories, that will generate the third-party external notice. Both of those have been done as well, as far as background check as well as municipality. And in the meantime, from a process standpoint, we're actively engaged with each applicant. If additional information is necessary, clarification may be necessary, we'll engage in that conversation with the applicants. And that's kind of where they stand as of now. That review is, of course, a priority, so I'm relatively confident that hopefully at our next meeting, I can be able to bring 1, if not both, of those applications for the Commission for consideration. But of course, it depends on the results of that background check and any third-party notice, municipal reaction. But given where we stand as far as the review at this point, I'm relatively confident.
Any questions? The map.
So next slide is the map of Massachusetts. And you see the breakdown. And actually, I regret I did not pull the data from last week, but those 10 applications are spread across Massachusetts. Not a lot of change as far as the Cape Islands are concerned, or Suffolk County, but again, Worcester County continues to be the predominant location for many of the applications we've received.
Questions? Anything else on status of license applications?
Nope.
Okay. And let's go to the next agenda item, which is guidance for farmers. Want to thank again Commissioner Doyle for her leadership on this, and again, I know a lot of staff's been involved, so I'd ask you to recognize the staff involvement, but the leadership of this and the driving force has been Commissioner Doyle, and so it's greatly appreciated. Our new expert on agriculture, energy consumption. What else do we have to add to your list? It's a growing and impressive list.
As is the industry. Thank you, Mr. Chairman. And yes, I would like to acknowledge many hands contributing to the guidance for farmers. What essentially it is a consolidation of and summarization of regulations that pertain to farmers and cultivators, as well as answers to some frequently asked questions and easy reference to particular issues. So I would ask if there are no questions by the commissioners regarding the guidance that we approve it subject to the fixing of the usual formatting, spelling.
Are there questions for Commissioner Doyle or comments?
I don't have any questions, but I just wanted to acknowledge the timeliness of this. At the last Public Safety and Community Mitigation Subcommittee meeting, there were some questions that had been raised by town managers and administrators in the central part of the state relative to exactly the information that is included in this guidance. And so this is timely and appreciated. So thank you to Commissioner Doyle for putting it together.
Other questions or comments?
Yes, I also want to thank Commissioner Doyle for her hard work on this. I do not have any edits to it. I have a suggestion, which is in the discusses alternate security provisions. In our next guidance, there's a form that goes with the guidance, that's a waiver form, and so I wanted to suggest that for the alternate security provisions, we may also have a waiver form.
Yeah, I totally agree with that suggestion, and the process of doing so, I believe, has been initiated. So hopefully we'll see that soon.
Other comments, questions? Excuse me. Then I'd ask for a motion to approve, subject to final formatting and editing, the guidance for farmers.
So moved.
Second.
Clerk Cho, Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor?
Aye.
Oh, sorry, I didn't hear you. Let the record show the commission unanimously approved the guidance for farmers to be released. Thank you very much again, Commissioner Doyle. I think the next topic is going to be led, the conversation is going to be led by our Executive Director. So, Mr. Executive Director, can you give us an overview of this document, please?
Sure, thank you, Mr. Chairman. We received a number of questions from applicants and provisional licensees relative to the agent registration process and how that coincides with their existing status in many cases as an RMD license to the Department of Public Health, which has similar requirements for an agent registration, that the applicant and the licensee conduct a CORI and maintain that CORI on their proposed agents. The question is, given that the Department of Public Health requires it and we require it, is that something that is intended to be a duplicate process, or can folks use that same CORI for that simultaneous agent registration? So this guidance goes into discuss that, which is first lays out the requirements to be a marijuana establishment agent, that the individual be 21, never have been convicted of distribution of a controlled substance to minors or like offense in other jurisdictions, and lastly be deemed suitable in accordance with our regulations. We also have an agent registration process or application process on the Commission's Cannabis Industry Portal, and that requires the licensee to use information obtained in the CORI to provide us information of any additional background check information that would be relevant for the purposes of registration. The gist of this guidance, as well as the subsequent form that's attached, is to suggest that if an applicant or licensee requested to use the CORI, as long as it's been conducted and obtained within a year, because they're valid for a year, that they could seek a waiver from the Commission for the purpose of using that. We would maintain the ability during the course of our inspections to audit and inspect that CORI to ensure that it's compliant. We also ask through our traditional waiver process that is contemplated in the regulations that they give us some rationale for that waiver. The rationale listed in the regulations is that the compliance with the requirement would cause an undue hardship. Their non-compliance would not jeopardize the health or safety of any patient, customer, or the public. And lastly, they will institute compensating features acceptable to the Commission. The waiver request form goes further, and asking them to, that they will conduct a new CORI check, again, within that year time frame, that their last report, CORI that was generated was within the previous 365 days, that all background check information on the CORI is reported to us. Again, we're not asking them to submit the CORI to us, and that they will get a CORI within that additional time frame. So I'm happy to take any questions you may have. Further, it also indicates, and I think it's important for the Commission to acknowledge or be aware, that the waiver process would be administered at the staff level by myself or a designee of myself. I think really to ease that burden on the Commission level to make us a bit more efficient when turning these waiver requests around. So again, happy to take any questions you may have.
Are there questions? I guess my only question, is this waiver form available, or if not, when will it be available?
Once approved, we will certainly make it available.
Okay, and your timing for doing that will be?
Today or tomorrow.
Okay, great, thank you.
And we would ask in the course of the form itself would be submitted along with the application for agent registration, so we'd have it all condensed into one complete file.
Great. Are there questions or comments on that? Then can I have the a motion to approve the Executive Director's recommendation? Can I have a second, please?
Second.
Let the record show Commissioner McBride made the motion to approve and Commissioner Doyle made the second. All in favor?
Aye.
Let the record show the Commission unanimously approved the recommendation of the Executive Director. Thank you very much. Next topic is, as I mentioned, the public awareness campaign, and I really do want to just reemphasize this really has been the passion and the leadership of Commissioner Flanagan. There have been a lot of other people involved, but Commissioner Flanagan takes a role as commissioner, particularly with respect to her appointment as the public health expert on the commission. Takes that role very seriously, and I think the output that you're about to see is testimonial to that. So I want to thank you very much for your leadership and ask you to introduce the topic.
Thank you, Mr. Chairman. And I really want to thank those at DPH and at More Advertising, also on the Cannabis Control Commission, Cedric Sinclair, Martine Russell, and Julie Johnson. This has truly been a team effort. Many of you know that under Chapter 55, Section 51, we're mandated to do a public awareness campaign in conjunction with the Department of Public Health. And we've been working diligently over the past months to get this done. I want to really thank Governor Baker and Lieutenant Governor Polito for including money in the supplemental budget that will, once passed, eventually go towards this campaign and the rollout. You may know that under the law, the money is supposed to come from revenue generated by the sale of adult use of marijuana. We really believe that it's important to keep the trend of Massachusetts with very informative public awareness campaigns so that the citizens really truly understand what's here now in Massachusetts. Money had been previously appropriated in the supplemental budget back in May. Due to the fact that we didn't spend that money before the fiscal year of July 1st, it is now in the closeout stock awaiting legislative action. I'm very confident in the fact that our legislative partners up on Beacon Hill will act favorably on this item, and you'll see a whole host of a variety of methods from which this is going to be delivered. I know Cedric is going to go through it. I really think that it's important to note that to me it's vitally important to have a strong public awareness campaign. I think what we've learned, especially through the baseline study program, is there are some people who just don't know about this law. And we want to make sure that they know about this law and understand what this law is here in Massachusetts, and at the same time talk about youth prevention. We really want to ensure that this product is used correctly, is used legally, without diversion to children and to minors. So I'm really confident in the fact that this public awareness campaign will make a strong impact here in Massachusetts. We have a long history of having very impactful public awareness campaigns. And I think that this is just another in the long line. So Cedric, if you'd like to explain that.
Sure, thank you. So as Commissioner Flanagan noted, an act to ensure safe access to marijuana mandates that the Department of Public Health, in consultation with the Massachusetts Cannabis Control Commission, shall establish a science-based public awareness campaigns that inform the public about responsible use of marijuana and educate youth about marijuana use with the goal of decreasing the youth usage rate. Today I will review phase 1, an online campaign to educate youth about marijuana use with the goal of decreasing the youth usage rate, done in collaboration with DPH, commencing Monday, August 13th. And as well as phase 2, a fully integrated marketing campaign on youth prevention and responsible adult use. Later phases will address the dangers of manufacturing marijuana products at home and other identified education needs. So this scientific-based public awareness campaign is informed by a representative pre-survey of Massachusetts residents and 18 focus groups that took place in 3 locations, including 1 urban, 1 suburban, and 1 rural. The pre-survey sampled Massachusetts residents aged 21 plus and explores the knowledge, attitudes, and practices around cannabis and the new law. The campaign's effectiveness will be measured in a post-survey reassessing the knowledge, attitudes, and practices around cannabis and the new law in a comparable, separate, representative Massachusetts sample. So the focus group consisted of So the focus group consisted of 6 distinct cohorts, all consistent and weighted for Massachusetts diversity of race, geography, and other demographics to ensure that the campaign is truly reflective of the various education needs and preferences that may exist around Massachusetts communities. The robust feedback gathered provided significant insight that was used to make decisions on language choice, such as the need to use cannabis and marijuana interchangeably, logo design elements that effectively communicate and are compelling to a wide spectrum of constituents, and informed our understanding of the public's comprehension of the laws on marijuana, consumption, possession, and sale. The research insights gleaned in the focus groups underscored that the public had general awareness of the law. However, there is significant confusion and misunderstanding of the details. And it also demonstrated that parents and guardians desired talking tips about the law, forms of marijuana products that are now available, the effects of cannabis consumption on their children's health, and other concerns. As a result, we focused on key messaging points that include but aren't limited to clarification that the legal age is 21, not 18, prohibited activities such as crossing state lines and driving while consuming and/or impaired, tips on effective engagement between parents and children, and details about the risks of underage use of marijuana. In addition to the key messages, we developed a brand to drive engagement through our communication vehicles that would be compelling, enduring, and could speak to multiple target audiences, considering the high competition for constituents' attention, the diversity of our constituents, and the need for brand extensions for future public education needs. So this is the brand, More About Marijuana. The brand that the work group developed has an empowering tagline that's a call to action for constituents to learn more about marijuana. The inclusion of the state outline speaks directly to our citizens and leverages the Commonwealth's positive brand equity. And according to color psychology, blues and greens are associated with trust, safety, and reliability, supporting the intentional development of a scientific, fact-based campaign that is both approachable and friendly. And so our media plan includes broadcasts, and the broadcast piece will launch in phase 2. It's designed to generate high awareness of the need for responsible behavior from adult consumers and the prevention of youth use, as well as increased messaging coverage in communities that have limited access to internet and our digital portion of the campaign. If you wouldn't mind playing the first video on the left. Just click.
I didn't know how to do that.
You don't get to do that.
Yeah, I don't think I have the technology to do that available.
First video?
Yes.
We got sound now?
Marijuana is now legal in Massachusetts for adults 21 or older. But parents are asking, what do we tell our kids? You're probably already talking with them about alcohol, tobacco, and opioids. Now is the perfect time to add marijuana to the conversation. Listen to what they have to say. Make sure they know that you want them to be healthy and safe. Give your kids the facts, but set clear rules about marijuana use. For tips on how to keep your kids safe, visit moreaboutmj.org.
Thank you. So the 30-second youth prevention spot is also accompanied by a responsible adult use ad. There are also other 15, 30, and 60-second spots that provide additional details or explore specific subject matter focus and are more appropriate for the digital outlets that are being used in phase 2. But in phase 1, the focus is on youth prevention and the digital media. These digital campaign tactics will be highly effective in targeting key constituents, identifying attribution of successful tactics, and scaling scope as budget and education needs evolve. These tactics will target relevant websites and major social media channels such as Facebook, Twitter, Instagram, through the use of Google AdWords and social media marketing. We also have out-of-home, billboards, transit, etc. And this will be another aspect of phase 2. It also supports large-scale awareness of the campaign by targeting large cities as well as specific neighborhoods that may host a marijuana establishment. Some of the cities that are being targeted for transit advertising include Boston, Springfield, Brockton, Fitchburg, and Worcester. And the last major piece of our media plan is print collateral. We have developed 2 rack cards that provide constituents with useful information, such as tips for having discussions about marijuana with their children, facts about the risks of underage cannabis consumption, and crucial details about the laws that help consumers remain in compliance. And that is our campaign. Thank you.
Thank you very much. Are there questions for Commissioner Flanagan or for Cedric? Comments?
I just want to applaud Commissioner Flanagan and Cedric and everyone who worked on this. Wonderful.
That's a great job. And I like the logo. I also like the education I just received about the significance of color choice. I did not know that.
Everything is strategic, Mr. Chairman.
Okay. And I also want to thank Commissioner Flanagan for taking away my thunder by answering the question of who's paying for this and how it's going to be paid for, because you know I would have asked that question.
No, you're most certainly welcome to ask the question. Actually, there was some startup money that was given by the Department of Public Health, roughly $260,000 to fund the development and asset creation of the youth prevention and responsible use campaigns, and that goes towards the focus groups, the ads, the animations, and the printings, and things of that nature. Also, there's $40,000 the Department of Public Health funded to launch the 3-month digital-only Facebook and Google ad youth prevention campaign that Cedric talked about. And then the additional $2 million that is in the stock currently will be used for the remainder of the youth prevention and the commencement of the responsible use campaign. So, you know, we're very fortunate in Massachusetts because, as I said, Section 51 said that we had to wait until use revenues that we obtained from the use of from the sale of adult use of marijuana. But we really have been proactive in Massachusetts, and thanks to the governor, lieutenant governor, and the legislature, we'll be able to do this earlier than expected.
Yeah, I think that the lesson learned from other states is that they waited until after launch to do this, and I think that's a great lesson that we've learned, and you know, I'm glad that we got ahead of it.
No, and I think, you know, also just to mention, yesterday EOPS launched their Drive Sober campaign, which I was fortunate to stand alongside the Undersecretary Quilly and the Mass State Police and the Department of Transportation. So we're really taking this very seriously to say, you know what, it's here in Massachusetts. I think all of the rhetoric and the campaigns are over. You know we have to move forward with this, and so having public awareness campaigns for the consumers and the citizens of Massachusetts is really responsible.
So thanks, and thanks to DPH as well for their collaboration on this. Commissioner Brown?
I wanted to thank Commissioner Flanagan for all of her work and the versatile work put into this. I do have one question. The timing on this is great because we're sort of ahead of it, and also I think because students are heading back to school, everyone from your middle schoolers all the way up to college age. Is there a component of the campaign that is going to be focused on school personnel, social workers, guidance counselors, anything like that, or is that sort of, I mean, is there? I
think right now what we're doing is youth prevention, and we're trying to educate the public and also give parents the tools. But eventually, as we obtain revenues from the sale of marijuana, you'll see different components of education. Teachers and school nurses have really asked about messaging with regards to the population of students they deal with, whether it's middle school or high school, and I think that's going to be really important. The Department of Public Health actually rolled out a vaping campaign, you know, to talk about the dangers of vaping, and so we're hoping that that kind of spearheads some conversations with parents and students, but also to give it to the teachers.
I would also like to point interested parties to the state's clearinghouse, which has the rack cards, the printed materials that provide tips for not only parents, but just guardians and trusted adults to have these conversations with children.
I think that's fantastic. I would suggest that we may want to do some outreach maybe through David Lakeman or others to folks like the Mass Association of School Superintendents, the school committees, to get that information out and make sure that they are aware that it is out there. Because I think one of the things that we've identified, particularly as we come online with products like edibles, vaping, that there may be just an issue of identification. And so it's in addition to sort of talking about the risks and risk reduction practices, right? It's also the identification piece and just like sort of generating a conversation for educators so that they're aware of what's going on.
Yeah, and a couple of months ago I spoke with the Mid-Wachusett Principals Association. You know, they're looking for information. You know, a lot of school committee personnel, a lot of school personnel are just looking for additional information on what to talk to kids about, what exactly. And so the hope is that with the RAT cards, that they do go to 351 cities and towns. Most specifically, and I know I harp on this a lot, is the sections of the state that don't have internet. They're not going to be watching these YouTube videos, and we want to make sure that even they are included in this piece of it, but also so that, you know, your regional schools and your, you know, all of your schools from, you know, K to 12, but also for college age students, because we realize that that's a whole other conversation, that 18 to 21-year-old living on your own cohort that we really need to address. So we're hoping that the campaign grows over time, and we're fortunate that we were able to get it off the ground as quickly as we can before school starts.
Other comments or questions? Okay. So congratulations, and I'm looking forward to seeing you released. I don't think there's a vote necessary on this. Just thank you for your efforts. Next two topics I'm going to go through the sequence. As I mentioned, are carryovers from our last public meeting 2 weeks ago. First being guidance to on community host agreements, and again, my thanks to Commissioner McBride, who has been the driving force behind this. I'm going to ask you to lead the conversation here, including I guess some suggested edits that you have based upon the public comments that we received. So, Commissioner McBride.
So I don't know the exact number of comments that we received. Mr. Chairman, do you have that?
I have it upstairs.
36.
36, thank you.
So
I forgot to bring that document down with me.
I just didn't have to count up the number of comments, but we received comments of every variety. We received comments from folks on the industry side. We received comments from folks on the municipal side. We received comments from individuals who just have a general interest in the guidance and the rollout of the industry. So it was with that in mind that I have made a couple of suggested edits to the document. By and large, they are intended to clarify where there was some clarity that was needed or requested from commentators. There are components in here that reflect some specific requests. There are other pieces in here that, as I read through the comments and looked at the case law that supported this document, I realized that there may need to be a rephrasing to make it clear what the intent was. So I'm happy to sort of talk about this, but I also would want to open it up to my fellow commissioners for their suggestions about how we can make this a clear document in the event that we do decide to issue it. And also I think what the process should be in making this a clear document. It's a little bit difficult to do a markup here, you know, and sort of have it be something that is, I think, you know, a quality document. But I'm open to what that process would look like. And, you know, it may very well be because, as we said from the start, this is a fairly, it's a legal intensive document, and it's intended to be that way because the support here for the fee structure and for the approach to this really is found in the statute, but also in decisional law. That creates the foundation for what fees are, how they are treated, how they're interpreted, and that is something that, you know, has existed long before this commission was ever formed. And long before community impact fees and, you know, Chapter 94G were considered. So there are components of this that, you know, may require additional review. Although, you know, I think I'm comfortable with what I've suggested here at the commission.
So let me suggest, thank you. Let me suggest that we have a conversation about your suggested edits, other comments or suggestions, and then at the end of that conversation, see where we're at and have a separate conversation about what the next step in the process is, if that's okay. Let's separate those two conversations. Let's focus first on content. So go ahead, Commissioner Bowe.
This is actually just a quick housekeeping question. So the edit that just got circulated, this doesn't appear to be the entire agreement. So, sorry, guidance, yeah. So I just want to, because mine is.
Yeah, mine's not two-sided either.
So.
So I think we all got half of the document.
So, so there's supposed to be more. Should we take a
Can we,
quick
well,
recess?
I think can we take a short break and get 5 minutes? Would that be enough to get us complete documents?
Yeah.
How about 10? Yeah, I'll make it personal, please, for 10 minutes. Okay, so
That's a public awareness campaign.
yeah, that's a public awareness campaign. So we'll get back together at 10 to, okay, we're adjourned until then. Thank you for catching that. Okay, thank you. We're ready to get started again. I think the floor still belongs to you, Commissioner McBride. So if you'd walk us, my suggestion, if it's okay with you, let's go through your suggested edits, and then we'll ask for other comments and suggestions from the rest of the commission. Everybody has a two-sided copy now?
Yes.
Okay, great, thank you.
I apologize to everybody for that delay.
As I said, I'm grateful for it.
So again, just to remind sort of where we started this conversation, in producing this guidance, the hope is really to set some bumpers so that negotiations on host community agreements can proceed, and to provide our interpretation of what is on the paper, section 3B of chapter 94G. So it's with that in mind that I can go through this document, but it's also the caveat that this can't be everything to everyone. This can't be, and is not intended to be, exhaustive or exclusive. At the end of the day, the contract negotiations are negotiations between two willing parties to a contract, and to hamstring that negotiation, I think is not at all what was intended by the statute. In fact, I think the statute tried to provide what we are supplementing here through this guidance. And so it's with that in mind that I'll kind of walk through my edits to the guidance. So
Thank you.
the first one, if you look, it's the second full paragraph that begins under the statute. I've added a sentence at the end of that states the costs and impacts of hosting a marijuana establishment will understandably vary from municipality to municipality, and negotiated HCAs should reflect the particular impacts on the host community. I think that this was a really thoughtful comment by I.N.S.A, which, generally speaking, I found their comments to be actually very thoughtful. And what the suggestion there was really to define that these agreements are really going to vary from municipality to municipality. They shouldn't be a cookie cutter agreement, and that the impacts are going to be different depending on what types of marijuana establishments and municipality, the makeup of the municipality, geography, etc., right? And so these are things I think we all know and we all intuit, but that clarification is intended to make that clear.
Should we go through the whole set of comments and come back to that and comment on each individual?
The second edit is to the section entitled Community Impact Fee. Here, I edited the paragraph pretty significantly, and this was because I went back and reviewed my own work. I went back and reviewed some of the case law that I had gone over previously, and went back over previous drafts, and realized that there was information that was conveyed here that I think maybe did misstate or misconstrue what some of the case law was leading to. So here I've struck out a couple of sentences and inserted in place thereof. The fee charged must be in exchange for a benefit that is sufficiently specific and special to the marijuana establishment, and assessed in such a way that it justifies assessing the cost to this limited group as opposed to the general public, even if the public sees some benefit. Moreover, the fee should be reasonably designed to compensate the municipality for the costs of providing the benefit. What was struck out here substantively is the voluntariness part, and the reason for that is because following Emerson, there were a series of cases, one of which is Silva v. City of Attleboro, where the court states, the second factor of the Emerson College decision should not be understood as having described the essential characteristics shared by all fees, both regulatory and proprietary. Nothing in that case suggests that whether a charge is incurred voluntarily is relevant in the regulatory fee context. And the regulatory fee is what we're talking about in this case. So that's to clarify that.
What about the other changes that you, besides taking out the voluntary nature, what was the logic behind the change in language you were proposing?
It's really really honestly, it was because I think that it was, this is a phrasing that flows maybe a bit better in the absence of
Yeah, I don't see
that
substantive
sentence.
change other than voluntary, straight from voluntary.
Yeah.
Not missing anything.
So, okay, so the next edit is in the the next paragraph. So we had received comments that one alternative to a 3% community impact fee that's paid over time is a flat fee. So this comment is intended to get at the idea that a flat fee is okay, but you are still limited by 3%. And so I can appreciate, this goes back to the original comment that was offered by the city of Amherst, that municipalities are going to vary, and marijuana establishments are going to vary in terms of what makes sense to them. If a flat fee is something that makes sense, then I think that that should be accommodated here, provided that, again, you're staying within the constraints that are provided for the community impact fee. And I would also suggest, without kind of reaching a conclusion here, that to parties who are negotiating that, it may be viable to have a clawback term for flat fees that are paid in excess in the event that the fee, is over what is ultimately reflected in the cost provided at the end of the year. This next comment, individual conditions can vary widely. The following list should not be construed as exhaustive or exclusive, but merely serves as an illustration of conditions. This is really in response to comments that I think people were construing this list as kind of like, this is it, these are the terms that can be included in a host community agreement. And from the very beginning of this conversation, going all the way back to December, I have expressed my concern about really, kind of providing a ceiling. I think that this isn't intended to be a ceiling, this is intended to be a floor. These are options, these are things that I think we have seen. This isn't an exhaustive or exclusive list. And so I just want to make that clear to you in the event that we issue this guidance, that is what I would like to reflect here. Within that second bullet point, the changes to the municipal preference, the resident preference, is based on some federal case law that's come down about preferences in the past few years. And so this is really trying to make sure that we are not suggesting to parties to these agreements that they engage in something that's actually
in any other way.
Again, so the list of anticipated costs, this again is a suggested list. They're viable options. There are other things that could be included on this list. One additional suggestion was municipal inspection costs. I think that again, this isn't exhaustive or exclusive. And in fact, none of these, may ultimately be something that a municipality decides or decides to kind of put forth as a cost that would be under the community impact fee. But that again is just to let people know that this isn't an exhaustive list. The clarification down here is really to take into consideration that, as we say earlier in the guidance, we read conditions broadly, and the statute provides for, in fact requires, that the conditions be spelled out in a host community agreement. Any amount that is not a community impact fee, if it's an additional condition under the host community agreement, needs to follow through with the legal requirements that we have set forth in here about what fees are, what constitutes a fee. There needs to be a reasonable relation, and it needs to be something that is proportional. There's a proportionality between a cost or impact claimed by the community and the fee required of the marijuana establishment. And that's something that is espoused in case law. There's Supreme Court law, Kuhn's decision talks about that. In the nature of exactions, there needs to be a proportionality. And I think it's really important that we are marbling this throughout the guidance, because it's the law, but also because it's what makes sense of the policy. And it's what I think our hope and what we are aspiring to do is to allow people to engage in a way that's reasonable, reaches a reasonable agreement, takes into consideration factors, and really has an honest conversation about what the costs are going to be associated here, and dials down some of the rhetoric that has been out there. I mean, at the end of the day, everyone who is engaging in these conversations are adults. They are people that engage in business relationships and engage in contracting relationships and are equipped to be able to reach a successful agreement, perhaps with some assistance as provided here. But I really hope that in providing this and sort of reminding and reiterating that reasonableness and proportionality are something that we've tried to carry this through, I think, in our regulations. I think we've tried to carry through in the guidances that we have put out to date. And in fact, it's something that, if we go back to question 4, is reflected in the local control language that was included in question 4. And so there's a consistency here that I am hopeful we can really try to get people to, come to the table and act in a way that's reasonable. And then the final edit here is the community impact fee is limited to a term of 5 years. We received comments from both folks who I consider kind of on the industry side and on the municipal side, asking for clarification here. And so the clarification that I would suggest is a final couple of sentences at the end. At or before the conclusion of the term of the preceding community impact fee, the parties may choose to negotiate a new optional community impact fee, which shall similarly be limited to a term of 5 years or less. Regardless of whether the parties choose to negotiate a new community impact fee, the Commission interprets the strict time limitation of Chapter 94G, Section 3B as extinguishing the preceding community impact fee upon the expiration of 5 years or less, whichever was originally agreed to by the parties. This is intended to say you can negotiate a new optional fee at the end of 5 years, or the end of, if you decide to do a community impact fee that's limited to 1 year because you really want to keep an eye on those costs and come back in and talk about those costs. You can negotiate a new community impact fee. That new community impact fee starts when that negotiation is concluded. If it happens to be that it's concluded on day 366 of the old fee, then it starts on that day. But the pre-existing community impact fee is over at the end of that term. I think that is what the statute suggests to us, that's what they tell us in the statute as the limitation. And I think that's a fair interpretation that is given to the statute. So in an effort to clarify that these aren't kind of rolling fees, I would like to include something like this in the guidance.
Thank you. Can we start with just comments on the suggested edits and Commissioner Bryan, and we can broaden into other concerns or questions?
Sure, I have a
Commissioner Dora?
very dull and technical question.
I will resist the comment.
Everyone who would like to zone out for a second. One of the things that I think has led to some misunderstanding and perhaps resentment amongst the contracting parties is lack of familiarity with municipal processes in terms of things like the costs associated with acquiring a special permit and the costs that are often imposed on an applicant seeking, for example, a request for determination of applicability or notice of intent with regard to wetlands or other environmental areas. And finding out that there is this ability of municipalities to ask the applicant to fund studies, fund even hiring an expert by the municipality, et cetera. And what I wasn't clear on when I was just scanning this, and obviously it was a bit quick, so I may have just missed it, is are we clarifying that issue as something that is perhaps separate and apart from a community impact fee, because I personally had never thought of that kind of thing as being part of a community impact fee, because the typical way I think this process goes is you negotiate the host community agreement and then local permitting is sought afterwards. So just from a practical standpoint, it may be difficult to discern what these costs associated with permitting are up front. It may not be impossible, it's just difficult, and we're talking about different arms of the municipal government. So, you know, typically the administration would negotiate a host community agreement, that you have the Conservation Commission, one board that deals with environmental issues, you have the zoning board or the planning board that may be dealing with other permits that are required for the particular location. And I wonder if we could provide some clarity, if we haven't already.
So in that paragraph under number 2, the HC must limit the community impact fee. So the second paragraph that starts any fee that is more than 3%. Mm-hmm. So there I added in the second sentence, moreover, any fee whether characterized as a fee, donation, or other exaction, including any assessment above 3% of gross sales, must also comply with applicable law. So in that instance, I'm going to mistake the general laws, but it's chapter 40, and I believe chapter 44, that talks about municipal permitting processes and exactly what Commissioner Doyle just referenced, that there is this ability to request that. I do not view the requirements of section 3B of 94G as extinguishing all other applicable laws. That can't be what happens. It just isn't functionally how the passage of statutes works. It's not how law works, right? So here, I believe that, again, in an effort to provide guidance so that people can move forward, this delineates our interpretation, or what I would surmise as our interpretation, or suggest as our interpretation of section 3D, but it's not so exhaustive as to go into every possible iteration of contracting law. So I do think that there are applicable laws that are still going to come into play when there is a contract that's being worked out. That if it is a fee that is going to be charged, it clearly needs to comply with that law. I believe that across the board, it should be proportional and it should be reasonable, and I think that that is not an unreasonable interpretation of how municipalities and marijuana establishments should be interacting. That's my hope for how people would be interacting. So that was the attempt to sort of say, there is other applicable law here. You need to be complying with that law, but acting in a way that's reasonable and proportional.
Thank you. That was helpful.
Other comments on these suggested edits? Commissioner Cobb?
I support all the edits. I think they're great. I would add to the discussion that we just had that it does make sense, I think, to me, that a special permitting fee would not be included in the community impact fee, assuming that the community impact fee is truly a list of reasonably related costs and not just 3% without the list.
Right.
So maybe the best way we could address that is, I would suggest that instead of saying must also comply with applicable law and deleting the legal requirements discussed above, we just add applicable law including the legal requirements discussed above.
I don't really have a problem with that edit. I guess the reason I struck out the legal requirements discussed above is because I actually felt like adding this final sentence was reiterating, it was kind of before we were sort of referring people back up, and this is where I wanted to make it very clear that what we're talking about isn't just isn't just Emerson, and it's not just the 3%. This really is applicable. The idea of proportionality and reasonable is going to be, you know, applicable to all of the components. Again, that's my view of how that negotiation should happen, that there should be a reasonable relation and it should be proportional. So I'm fine with putting that back in. It feels like a little bit, I don't know that it's necessary, but if you think it's clarifying, then I'm happy to put that back in.
I mean, I think it applies either way, but I do think that helps. And then one other thing, looking at the new sentence, I think it would be helpful to add one more sentence that is really just copy and pasted from the law, but if you don't have the law in front of you, I think it's important to include this for context, that the host community agreement shall include all stipulations of responsibilities between the host community and the marijuana establishment.
Can I just ask two clarifying questions? One is, in the list of things that are, you know, and again, I appreciate your language about it's not meant to be an inclusive or exclusive list of things that can be included in the community agreement. One of the things that came up in comments that I read is towns and cities charging for expert advice they're getting in the negotiation of the HCA, so whether they're talking about lawyers or consultants or other experts that help them negotiate the agreement, is that actually a legitimate cost to be covered by the HCA? And I'm just not clear in my own mind whether that is something that is legitimate or not, or whether it's something we should take a position on or not. I'd be interested in your thoughts, Commissioner McBride. Or others.
Do you want me to do that?
I know, I can have that.
Oh, anybody?
Falling back and forth. So that is consistent with what is done with other kinds of permits. And I have, you know, obviously heard municipal attorneys recommending, as you know, as we're doing these municipal outreach engagements, we've had different municipal lawyers often on panels with us, and I've heard, you know, them suggest, particularly with small towns in Western Massachusetts, it's very difficult for them with a constrained legal budget to even be able to engage in any kind of extended negotiation process. So I actually think it's a helpful thing to have that funded, because then they're more likely to be willing to engage rather than to say, oh, we can't afford to even deal with this ban, moratorium, whatever the other alternative is. I would like to, you know, try to keep our approach to this as consistent with what's already out there, and then also do it in a way that encourages municipalities to be flexible and open-minded and actually approach this in a non-boilerplate cookie cutter way.
Yeah, so that makes perfect sense to me. I'd like to just ask for your comments on this kind of corollary, which is, in every conversation we've ever had, this going back to December, my concern is not with the big guys, it's with the smaller entrepreneurs that we're trying to encourage to participate in this industry. And I make the same argument for them, which is they don't have the resources to engage this way. And so by essentially, force is the wrong word, but in the community agreement, if they cover the cost of the municipality, it seems a little bit disproportionate. Their own expense in negotiating this is not covered. And so I'd just be interested in your reaction to that, or anybody else's. But your logic makes sense. That's the concern I have with it.
No, I absolutely agree with you. I think one of the chief issues for the economic opportunity applicants is going to be the funding even to get going,
right,
including these issues. And that's, you know, part of my plea to municipalities is please be flexible. You know, please don't approach this as a one-size-fits-all thing. If you are working with a small business, don't immediately demand an enormous sum of money
in that activity in the first place. So I guess there were a couple pieces there. I questioned legal authority, and then I questioned actually what the implications would be of engaging in the process.
So Thank you. This is an important issue, and I think one of the things that I'm observing in this is that, you know, we're not really sure what's going on. We're not sure. There seems to be an issue here. I agree with your assessment, but it's a qualitative assessment. I think most communities are acting in good faith, but there seems to be at least enough smoke to suggest that there's an issue here. I am concerned that there's an issue here. I do believe that it's a timely issue, that before we issue a final license, we do need to make a decision on if and how we're going to get involved in this process. I also agree with Commissioner McBride, and again, as a non-attorney, listening to the advice of counsel, I don't think we have the authority to interfere in these agreements. I do think we have the authority to reject an application, but I agree with you also, Commissioner McBride, that will lead to litigation in all likelihood. So I think there's a middle ground, as I've been thinking about it, that I would like to propose. I don't know if it's going to make sense to the rest of you, but I first of all would like to really get a better understanding of what's going on. And right now, if I'm correct, Mr. Executive Director, in our applications, we do not require a copy of, we require certification that a host community agreement has been reached, but we do not require a copy.
That's correct.
We have asked, I believe, for voluntary submission of those agreements, or have we not?
Through the municipal survey, there is a.
That's the, okay. I don't believe, and again, I'd be interested in council's advice here, I don't believe that it is possible to require that without a change in regulations in terms of the licensing process. But if there's a way to more strongly encourage the submission of the actual agreements with the application, I personally would just like to see them, as I think the rest of the commission would, just to see what's going on here, as opposed to hearing secondhand and seeing only a relatively small percentage of the agreements. I just don't, I can't really quantify what's going on here because it's anecdotal. And I would really think it would be beneficial to us as a group to see as many of these, if not all of them, as possible. And I'm not sure what the right method is to get compliance there, but I would certainly like to try and then require change our regulations at the appropriate time. But the second thing I would like to do is, if we can get these agreements, and even if we can't, I would like to request the executive director and the staff to, in your recommendation document that you submit for the license applications, where you go through, you know, here's what's in the operating part of the agreement, here's you know, who the principals are and so forth. I would like to request that we add a section that is, what's the community host agreement? And what does it say in terms of numbers? What does it say in terms of justification? Not as a basis for recommending review or, you know, approval or denial, but just as part of the record. And I think a couple things will happen that will be beneficial. One is, I think we'll bring some more data to bear on this question, because right now, as I said, I'm feeling that we're trying to make a decision on anecdotal data, very incomplete anecdotal data. Two is, I am a firm believer in the Hawthorne effect, which is you shine a light on something and people change their behavior. And so I believe making this part of our deliberation, and more importantly, making part of the public record would be beneficial. And I believe mostly what would be beneficial is, as I said, the opportunity for us to get more information and more detail on what exactly is going on and what do these agreements look like. I agree with you, we don't have enforcement, so I'm not suggesting a review that would say, no, this is not an acceptable agreement, because I don't think we have the basis for doing that. I would like to see what's in these agreements, and I would like that to be kind of the standard part of our evaluating the license. So I don't know if that works, it's kind of the middle ground, but that would be my suggestion.
The municipal survey, just to be.
Yeah, I don't know how much we get done.
So, relatively feedback, but we just sent it out. We should get it back by the end of August, possibly August 24th or 25th. I'm guessing, don't hold me to that date, I just can't remember it at the moment.
I don't remember what day it was when I started this meeting. So.
It's obviously difficult when you're working as fast as we are. So we should, within this month, have the completed responses of the municipal survey, including the communities that have provided host community agreements. They're also supposed to report to us what their status is, so they obviously can't give us a host community agreement that they're in mid-negotiations on. But we will get what we have. We can also cross-compare what we have received with our application data in terms of who's reported that they have an agreement.
And aren't these public record?
Yeah.
So we without asking for submission, we can just go get them ourselves, is that correct?
You could request them, yeah.
Again,
operating on unsound territory myself.
I think that Commissioner Title raised previously that as we're going through our process of inspections at marijuana establishments, we can request documentation, and where that documentation
So we can,
is the host community.
So without changing our regulations, do you believe we can actually, it's probably not in the provisional licensing step, but in the final licensing step, as we request documents?
Well, I think that without having our regulations right in front of us, that would be something that would be a review on site, as opposed to, a submission to us. That means the submission piece of it being something that, I think that does require a change in our regulation, but the review on site, I think, is something that can be accomplished.
Great. What are your thoughts?
On the issue of penalizing the applicant,
Pardon?
on the issue of penalizing the applicants, I didn't mean to be callous about it, but this is one of many, many, many areas of the law that the applicant has to be compliant with. And so I'm not sure what is different about this area versus everything else that we regulate, one. Two, in terms of effectuating a change in the agreement or interfering with the contract, again, I really think that's something of a straw man, because nobody is suggesting that we have any right to interfere with a contract between a municipality and an applicant. What we have the right to do, I believe, is to ensure that they have a legal community host agreement before we issue a license. I think we are at something of a fork in the road here, where on one hand, we can say, well, we set up all these great policies, we set up an economic empowerment priority program, that's what the law said. They get priority if they apply, but they didn't apply, so oh well. We took a hands-off approach on the community host agreements. We haven't seen any evidence. I think we have seen evidence. I think there has been a light that has been shown on these agreements. They say things like 4%. They say things like 3% plus $100,000 flat fee. They say things like, this is an RFQ where you have, an RFP where you have to show that you'll give us 3% of your gross annual sales plus additional guaranteed money. I've seen all of these. So the question is, and I think much of the comments that we received were trying to push us in this direction, will we throw our hands up and say, well, we did what we could, but we set up the kiddie table, but when it comes time to issue the licenses, these are the people who are going to get the licenses? Or are we going to go in the other direction? And I think we will. I think if you look at the work that every commissioner is doing around the state, that you'll see we are not taking the easiest possible path. We're not saying, oh, if someone writes to us that there might be a legal challenge, that we just suddenly shy away. We look at where we are today, we reevaluate, we take public comment, we have a complex, challenging conversation, and then we make a decision. Leave it at that.
Commissioner Planning?
So, I raised the concern 2 weeks ago that what's our legal authorization or responsibility, and can we do this? I've been around the state as much as fellow commissioners have. A concern that I have is that we received 30-something responses.
36.
And we have 351 cities and towns. And to me, while I'm not always the numbers person,
That's just over 10%.
that's not hardly anything, because I think that if we are to look at these agreements, if we're asking for the community host agreements to be made public, we have no idea what went into those negotiations. I think we've done a lot of work here, specifically around the little guy, and I will continue to fight for the little guy. They're not gonna make a town as much money as the bigger guy, I mean, hands down. We've set up licenses for small craft cultivators, we've set up licenses for transporters, we've set up licenses, and I think they're gonna get lost in this regardless of what we do. And that's part of my fear, is that we're talking big money, we're talking 3% plus, you know, money paid to a city and town. I've seen some of the community host agreements. I don't agree necessarily with the provisions, but I also wasn't sitting at the table when this was done. So I think we have to be, I agree, we have to be thorough. We've made a ton of difficult decisions since September 1st of last year. We've done it in short order. We continue to do this at an expedited pathway. And I think we have to be very thoughtful to the process. And while I appreciate the comments that we have to do it now, because I agree, we can't be treating applicants differently, you know, a year from now than we have been treating them now. I guess that's part of being in the foray to this industry here in Massachusetts. But my concern is that if we start collecting community host agreements and we start looking at them and what's in those agreements, I mean, listen to Amherst. Every town is different. Their needs are different. So the question I have is, what are we comparing? We can say 3% and we can say don't go over the 3%. We can say it has to be relatively related to the impact, but for every city and town, that's gonna be so different. And so I'm just stating the concerns I have. I'm not saying which way we should go, because I think we do have to figure that out collectively. But I really think that we've got to figure out what we want the end game to be. Like, what do we want the end result to be? Before we go to the staff and say, start going through these community host agreements and putting it in your recommendations and giving it to us. And while I understand, Mr. Chairman, you said the Hawthorne effect was that when we start exposing this, people may act differently. I think right now there's some tension between cities and towns trying to find that gap to fulfill the needs they have in their town, with businesses who are trying to legally set up in those cities and towns. So I don't know which way I'm gonna go yet.
Sure.
I think it's just we have to be very thoughtful through the process.
I appreciate that. I just wanted to just interject on one of the things you said, because I think you made a lot of very valid points. If I were reviewing this, forget about the staff for a second, but if I were reviewing these, I would not look at the numbers. I would not look at, well, it's going to be $12,000 for an extra police detail here, or $27,000 for traffic cones here, or whatever, because I don't feel I'm confident. I mean, I agree with you that each city and town is unique, and so I don't feel like I'm confident. What I would like to see, however, is that there is that kind of justification. What specifically are the incremental costs that these cities or towns are going to incur, and is it documented in that it's not just a made-up number, it's not just 3% because 3% is the rule, it's not 4% because it's just what is the documentation support for that. And so I feel confident myself, and I certainly feel confident in the staff's confidence to look at it in that way, not to look at the individual numbers, because again, it's very different, but to see, is there a justification for the fee being charged? I feel very confident in our staff's ability to do that.
With a better understanding of what your thought is as to what would be reported.
Yeah.
I'm not sure that actually I can say with some degree of
I'm sorry?
certainty. I can say with some degree of certainty that that information is likely not going to be included in a host community agreement, and the reason for that is because by the contracting terms and also what's included in the statute, it has to reflect the conditions, it's got to reflect the stipulations of responsibility, but the particularly specialized, the specific pieces of it, those are parts that come into play during the course of the negotiation, but that's not necessarily going to be documented.
Well, forget about us for a second and what authority we have, which I understand is a separate issue, but if the law says that it has to be proportionate to the actual cost, if this were litigated, how would a court determine whether it was indeed proportional to the actual costs that are going to be incurred?
There'd be discovery that would be done during the course of the lawsuit.
I'm not sure why we couldn't ask for people to put that into the document. I guess I don't. We can. I'm very much in alignment. I'm not sure I agree with Commissioner Title's suggestion, but I do agree with her that we can just throw our hands up and say we can't do anything here. I personally believe that would be shirking our responsibility. So I'm more than happy to have other suggestions about what we can and cannot do, but I absolutely believe we need to do something. So I really appreciate kind of if what I'm suggesting won't work, which I respect your point of view, what can we do?
I honestly don't know what we can do. And the
sorry to
reason-
put you on the spot like that. I
But I mean, the
apologize.
reason for that is ground that we've already tread. We don't have an ability to say to a municipality, if we were to get this information and have it in front of us and identify that there were an issue, we don't have any authority to go back to a municipality and say, right.
I
So
understand
then
that. I was not proposing that.
we deny the application, right?
I'm not proposing that either.
Okay, so those are both not, so the proposal is that we're going to go and look at the documents at an applicant's site.
Right.
Okay.
Well, there's two objectives I have, since I agree with you, we can't tell the city or town what to do. We cannot nullify a contract, that's decided between two independent parties. All I'm saying is I want to do two things. One is I want to know what the problem is. I want more data than we have currently on how much of a problem this is, how widespread it is, because I agree with your assessment. Most cities and towns are operating good faith, and there's some exceptions. I don't know how many exceptions there are. I really think that we'd all be better off knowing what the problem is and having more data on what
May I
you know.
ask a question on that?
Pardon?
On that one piece of it, can I ask a question?
Sure.
If it only happened one time,
I agree.
why, if it doesn't apply to that
No,
municipality, why would all of the others follow the law?
It's
So
not
why
so-
does it matter how many times?
It's not so much the number of times, it's what's going on, and what are people asking for in these agreements. So it's more that than the number. I agree with you, one time is one too many. I certainly agree with that. So I want more data, so we can make an, I don't know if we can change the outcome, because I'm not sure what we can do, but at least we know how big the problem, how the problem is. Second thing, I really do, it's unprovable in government, but I know it works in the private sector. The Hawthorne effect works. If people know that what they're doing is going to be exposed to the public, they will think twice, and maybe they won't change their behavior at all, but maybe they will. And I don't see any cost whatsoever to try. So I think there's two benefits. What I won't agree to is just saying we can't do anything.
So, can I just ask one question? Sorry, question. You say you want data. Isn't what that what the 2-week comment period was supposed to give us? People to be able to send us what the issues are or what their concerns are. And I just feel like we, to Commissioner Title's point, if one is one too many, and we've asked for a 2-week comment period and we got back 30 some odd responses.
36.
How much more are we going to do as a commission to get people to give us that feedback? I mean,
well, I'm not asking for feedback, I'm asking for the contract, so I'm not asking for feedback. 36 things we got were feedback, and I think that's valuable, and I appreciate it. As you pointed out, 36 is not a lot of comments when there are 351 cities and towns in the state, so I think that the more information I'm looking for is contract, not comments. And two, as I said, they work simultaneously, but exposing this to fresh air, I think would be beneficial. Exposing these contracts to fresh air, I think would be beneficial. So the comments don't do that. So I agree with you. The comments were very valuable.
I just want to, so I don't disagree that illuminating the issues and where there are problems is helpful. I guess
you don't disagree that you used too many negatives for me there.
I agree with you.
Okay, that's what I was shocked by.
But I guess my question really is, given that I think it seems like we agree, or I don't know, correct me if I'm wrong.
I think you're being optimistic.
We have limited authority, right? And the authority that we do have, there's some question as to whether we are comfortable exercising that authority against that particular party. I have no concerns about that. What, if we get this information, what are we doing with it? I mean, is it an airing out in the public square?
Well, I think there's two things.
Holding up post community agreements and saying, we have a concern here, and then if we do that, then what?
Well, I think there's two things. I mean, one is I do believe that airing it out in the public sector is not the language I would have chosen, but I believe there's benefit to that. But to me, we know what our limitations are currently. If this, based upon reviewing these and seeing how it plays out over time, We have the option of at least two things. One is going to the legislature and asking them to modify the legislation. I'm not saying we should do that. I'm just saying that that's certainly an option down the road if this is a persistent and important issue. The second is we have the option of changing our regulations if that can address the problem at the appropriate time. So, you know, I know right now our hands are, we have to enforce the law as it is right now. And we have to enforce our regulations as they are right now. And I think based upon those two things, we have limited options here. I'm totally convinced that you're right, that we have very limited options here. But if we get more data and study this issue, I think we have longer term, lots of options, including going, as I said, to the legislature and asking for changes or proposing a change to our own regulations at the appropriate time. And I won't forecast or speculate on whether that will be appropriate or not, but I think those are options absolutely down the road.
Okay, so then my second question is, what's our standard for reviewing these documents?
I think we have to, be very precise about that, and I'm not prepared to, offer a specific process, but if your point is that we need a process that's very explicit, I agree with that.
And then, I guess the third part of that is, we need to be, I think, very realistic. If we decide to go down this road, which I'm not.
I know.
If we decide to go down this road, we need to be realistic in setting the expectations of the people who are looking for responses from us, i.e. the applicants. Okay, so we, under the law, by statute, have a 90-day window. This is adding, if we decided to go down this route, right, we're adding an additional piece. And I don't know, because I haven't, I've heard from people that, oh, it'll take you 12 minutes once you get used to looking at these. Right. And I'm skeptical.
Yeah, I don't know. You're absolutely right. We need a very specifically well-defined process, and I have not given that any thought. So I don't know what that would look like, and therefore I don't have an answer to your question about what the resource or time requirements are. And I think those are very legitimate concerns that I just can't respond to right now.
Yeah, so that's fine. If we can't respond to them right now, but.
Well, I can't. I don't know if others can, but I can't.
Okay, but I want to put that out there because, again, we're going to go back to it's not lost on me the irony of putting in place an additional process in order to expedite a process.
Right.
So I'm kind of I'm curious, and you've intrigued me. So
I can do what to you?
You've intrigued me.
Oh,
so I'd like to kind of understand from you, Mr. Chairman, and others, what that process looks like, and what the time commitment would be in that, and what the expectation setting is that we need to do with applicants, because I'm very concerned that we are going to be in an effort with the best of intentions. We're going to be getting ourselves into a bureaucratic quagmire that is going to be quickly hard to resolve.
Yeah, I think those are very legitimate concerns. It's that I do not have responses to them, but I am also convinced that we can provide responses that hopefully will assuage those concerns, because I think they're very legitimate. So, Commissioner Todd?
So it seems like the two items that people have questions on are what kind of authority do we have, and what would this process look like for the staff, and kind of proportionate to the existing process, how much more would it add?
Well, I think so. I don't think that it's an authority question, because I think that we have authority to actually go into a site and to look at their documentation. I think that getting the back end numbers, back end client stuff, that
we don't have the right to discovery. But.
My question is about the standards. What standard would be used? How much, understanding that we've got to standardize it for all of our licensing folks, right, to be able to apply this in a way that is, across the board, right, fair. What's that standard look like? How much time is it going to take to do that? And a part B to that is, if we find something that is questionable, what are we, doing, I guess, in the context of our limited.
Yeah, I think that's well said. I don't mean to interrupt.
Thank you. So what I was going to say, so it doesn't sound like there actually is a question on the authority. We're all in agreement that we could deny the license, but whether that is the right idea is an issue. I would just raise on that point that it's not a question of just the applications in front of us. If we have someone with a community host agreement that goes beyond what's in the guidance, and either we deny it during a meeting, or our staff goes back to them and says, this isn't compliant, come back when you have an agreement that does comply. What that sets is a path forward where every community host agreement then has to meet the standards of the law. So that is what I'm trying to get at. I'm not trying to get at denying applicants. The other thing to think about is, what about all of those applicants, and we heard from many of them, prospective applicants that don't have a community host agreement because they weren't able to agree to those conditions, and they don't even come in front of us to approve or deny. We have to think about them too. I would suggest on the question of what the staff process might be and how long it might take, that we get an opinion from the staff on that and then come back to this discussion.
I was going to suggest that that's the case. That's exactly what we do. Is come back with a recommended process. I would like to participate with the staff as appropriate in terms of the way this is what I think the review should look like in terms of how it happens and how the staff is allocated to do it. That's obviously on the executive director's perspective. But I'd like to do exactly that and address all of the issues that Commissioner McBride in that proposal from the staff, address all the issues that Commissioner McBride raised, not just in terms of the process, but in terms of resources, timing. Does it add to our to the timing of the process? How can we make sure we have a statutory requirement to stay within 90 days? Once we have a complete application, can we make sure that happens and doesn't create risks there? And I explicitly want to address the last point I think that Commissioner McBride meant, which is we need to set expectations that we don't have a magic wand here, and make sure that people, that whatever intervention we can do, people clearly understand, and the things that we cannot do, people clearly understand. So I think there needs to be a communication strategy as part of the recommendation from the staff to address that concern. But I think that would be my proposal. I agree with you, but with Commissioner, I think this is mission critical and urgent. So I would hope it's possible, Mr. Executive Director, that we could address this at our next meeting.
Is the time issue with that?
Sure.
So I think our next meeting, assuming we stay on a Thursday and do two May, is the
Each day after Labor Day?
23rd.
23rd.
August.
Okay, I'm sorry, I'm really bad on calendars, go ahead.
So if it's the 23rd of August, we won't have all of these submissions back from the municipal survey, just based on my experience, not casting aspersions at all. But there were quite a few responses to the host community agreement that came in at the very last second. So we could see significant amounts of responses on the last 2 days. The next meeting after that, again, yeah, September 6th-ish. I know we're subject to getting space and all that. Is that something, can we do September 6th just to give us a little more information?
My only concern, I think it's legitimate, my concern with that request is, and I'm going to be really, really careful, because I do not want to see this on the front page of the paper about exactly when a final license is going to be issued, because I am not making a forecast about that. But we have to get this resolved before a final license gets issued. I believe, to your point about precedent. So that would be my only concern. So I know, Mr. Executive Director, what are your thoughts?
I guess if I could ask a question, and I guess I don't know who I'm posing to necessarily, but as far as when, because I want to make sure we are responsive as a staff to the inquiry here, is at what stage would we be inspecting the host community agreement for its, my reason being, there was some discussion earlier about including it in a executive summary provided to the commission of provisional. An inspection would not occur until after provisional is issued.
I think I'm inferring from the comments of Commissioner McBride that probably the only way we can enforce our ability to review is in the inspection process. So it would have to be as part of the final approval. That's what I think is the implication of what Commissioner McBride said. I don't know if you agree with that, Commissioner McBride.
I think that that's fair. I mean, I think that we don't have a regulation that asks for the submission right now, which means that we have to go on site in order to do that. And I would leave it up to the executive director, to the chief of investigations and enforcement, and the licensing staff to determine what that process would look like, how long it would take, and the understanding, as Mr. Chairman just pointed out, that if we're going to do this, we need to do it before we issue a final license, and we cannot issue a final license if we decide to do this until such time as that process is in place, and that has occurred. So, you know, I think that that's probably what we need to think about. And in addition to that, if we're going to have this be sort of the standard that we're moving forward with, then I think we need to have a very clear understanding of the staff that's going to be required as we become more diffuse geographically, and have just more to do, what we're going to need in order to be reviewing these documents. And again, and the standards piece of it is just a really critically important piece to me, because it cannot be that we have someone, you know, from our licensing staff that is reviewing things and treating it one way, and then, you know, person B is treating it a different way. And I think that that is easier said than done to set those standards. So,
I also want to pile on just and say, you know, I would expect to be told one of two things by your recommendation. One is that we need additional staff, because it's not we have spare capacity, people, you know, not working as hard as they possibly can right now. So either we need additional staff, or here's what is not going to be done if we take on this responsibility. I want to be very explicit about that, because I don't think it's just what we can just ask people to put more on their plate than they currently have. I think people's plates are, for the most part, extraordinarily full. Commissioner Dunn?
I just don't think that we need to overstate the recommendation here, which is simply to check for documentation of costs, the percentage of gross sales, or a flat fee with a limit of 3% of gross sales, a term of 5 years, and a sentence that says this includes all stipulations of responsibilities between the host community and the marijuana establishment. That is what we're discussing.
I have to disagree, Mr. Chairman, if I can.
Sure, absolutely. So it's your prerogative.
Yeah, I just don't think it's as simple as that, because I think in the statutory language, community impact fee is one thing, but it is not the only thing that can occasion monetary transfers between the marijuana establishment and the municipality, and that's where I think this gets incredibly complex. And earlier versions of the statute, including question 4, which I'm sure you're very familiar with, had a clearer cap. You know, everything had to fall under it, but the final language is different. And that's where I'm very concerned. If that's where it's just going to be difficult for our staff to get into the details of these agreements and determine whether or not they're compliant with the law. I think it's difficult to do, and so that's.
Yeah, I think we need to give the staff a chance to do that, but it's my opinion, we need to give staff a chance to do that. I'm certain that whomever Sean, their director, designates to come back to the commission with a recommendation will speak with all of us individually to get our input. But I'm confident that they can come up with something. I might be wrong, but I'm confident they can come up with something that addresses the complexities that you raised, the concerns that Commissioner Frye raised, and as I said, I think it's something that we have to do with a high degree of urgency. So I'll push back on the September 6th date and say I'd like to see it on the agenda if possible for the next meeting 2 weeks from today. I need Mr. Executive Director to tell me if that's doable or not, but that would be my preference.
We can do a lot of things. So I guess the reason I asked the question is that from a timing perspective, as well as the application, one gets submitted, reviewed. The application review is one element of a licensing process. Inspection is an entirely different element that we are in the middle of developing and actually implementing now.
Time is good, huh?
Sure. But I guess from a review and inspectional standpoint, reviewing and inspecting documents and auditing those documents, we will eventually, I think the commission, really, as said from the commissioners, we have a pretty good spirit of documentation and creating records. So I think this is something I will absolutely bring to the team, and we will wrestle with it as well. And as far as the next meeting, I think, of course we can, if that's the commission's request, of course we can do that.
So are we okay to move on from this, including deferring action on the guidance of Commissioner McBride, or should we actually issue, I'm not sure if it's inconsistent to issue the
guidance from.
I'm ready to vote.
And do
Yeah,
the.
they're different issues.
So are you okay with that?
My hope is that issuing this guidance is going to alleviate much of.
Well, we're gonna find out, so that's
Yeah,
great.
so-
So I guess,
So I'd like to make the motion to accept the guidance as.
I just want to ask one clarifying question. Are you comfortable, or do you think there's more, you said that you wanted, based upon this conversation, you were gonna reserve judgment about whether you're comfortable with it as is, or whether you thought it needed more work, so I'll ask you for your judgment on that.
I am comfortable with it, with the additional edits that were proposed by the commission. If others on the commission are comfortable with it, I am happy to move forward. If not, then I'm happy to delay the vote.
Okay, then I'll entertain the motion. Please, Commissioner Klein, your motion.
To approve the host community agreement guidance as changed by Commissioner Fry.
Second.
All in favor?
Aye.
Unanimously approved, so thank you very much, Commissioner Bryan, for all of your hard work on that. We have, I think, one more discussion topic. What I'm going to suggest is that we take a break after this, and before we get into the licensure conversation. So this is again guidance on equitable cannabis policies for municipalities. It was discussed 2 weeks ago. We agreed to come back after public comment to discuss whether modifications were required to the document. Since we're data happy today, we got 15 comments on local equity guidance. So Commissioner, kind of would you lead us through this conversation, please, and the suggested edits that you're recommending?
Yes, also I'd like to withdraw my motion if I made it. Thank you.
Oh, so, okay, sorry.
Okay, all right, so
Thank you.
we'll just go through page by page. Thank you, Polly. All right, so on page 2, I eliminated the section, what municipal entity or entities will oversee the prospective licensing process, based on Commissioner Doyle's suggestion, just eliminated it entirely. The next edit is a word change from our legal counsel, Christine Bailey. The next item is also a wording change by Commissioner Doyle.
So we don't look
Any
so
questions?
anachronistic. Is the package store change?
It's a clarification, we received comment back during the municipal outreach tour.
Page 3 is a paragraph that was rewritten based on Commissioner Doyle's suggestion that sort of restated the development of small business. So I took those changes in full. There was a typo of 2018 that was changed to 2019. Thank you to everybody who caught that in their feedback. A municipality may adopt a tax of up to 3% on adult use cannabis sales by a vote of its legislative body. Richard Evans's feedback suggested adding the word retail. The next sentence is a substantive suggested from I.N.S.A, Equitable Opportunities Now. If a community impact fee is included as part of the host community agreement, we encourage communities to consider lowering community impact fees for economic empowerment applicants. Later on page 4, additional buffer zones or separation requirements. That was a recommendation from the MMLA, Mass Municipal Lawyers Association. I think, okay, that we use the term separation requirements for separation between marijuana establishments. On page 5, 2 more comments from the MMLA. Again, separation requirements instead of buffer zone. And then as far as the suggestion that municipalities consider waiving or reducing the size of the buffer for certain applicants, they suggested there was a zoning uniformity issue there, so I cut it and replaced it with simply, we discourage municipalities from enacting any separation requirements. On page 6, this was a recommendation that came in from several individual commenters, as well as Equitable Opportunities Now, as well as Elevate. It was the most popular suggestion. We recommend that municipalities alternate signing host community agreements with economic empowerment applicants and non-economic empowerment applicants. On page 7, Commissioner Doyle suggested rewriting the host community agreement sentence to be clearer and eliminate the references to the entity being vetted for conflicts of interest and overseeing more than one entity. And those are all the changes.
Any comments or questions for Commissioner Tao? Please.
On page 4, where we have, we do the sentences, the very last sentence, at least the way it printed out for me, current studies do not show any evidence that, I've already discussed my discomfort with that, but as a compromise, could we list the studies that we're referring to? Because where we're referring to other studies, we've done that. And here we're sort of characterizing numerous studies. Can we list them or do an end note or something?
Yes,
Okay.
that's fair. So instead of saying current studies do not show, we would say like one study shows X and then cite it, a second study shows Y and then cite it.
If that's necessary, or if you could do, I think what's we know as a string site, yeah, the studies that are being referred to here, you know, sorry.
No, I know what it is, I just think it's, I just love your language.
And then if I can.
Keep going,
Okay.
please.
I'm having some discomfort with us telling.
What page?
I'm sorry, it's 2 different sentences, where we're talking in page 5, it's the new sentence, and I know you're trying to reach a compromise with, reaction to comments from the MMLA, where you're saying we discourage municipalities from enacting any separation requirements, and then, so that comment I'm having some discomfort with, and then, the next page, page 6, recommending alternate signing host community agreements with economic empowerment applicants. So just the reason that you're recommending that language on page 5 is the belief that it further shrinks the available real estate. Is that what it is?
Yes.
So to the extent we are providing this guidance to make recommendations to municipalities on ways to make more opportunities available to economic opportunity applicants, that's the basis for that?
Well, for the one on page 5.
The one on page 5.
I wouldn't say specifically economic empowerment applicants, it's more the idea that if you, as it says, exacerbate the scarcity of the real estate by suggesting, you know, you have to be 800 feet, for example, from another establishment, you're just further reducing the number of properties that are available, and that, as a general matter, discourages the applicants with fewer resources.
The smaller average,
Yes.
so that doesn't count.
Yes.
Okay, so that actually makes me feel more comfortable, it's just sort of letting them know, why are we telling them how to do?
And then back to 6.
Okay, and then on 6, so you're recommending this because this is a way for municipalities to try to balance out providing general or priority R&D applicants opportunities as well as economic empowerment applicants.
Yeah, sort of mirroring what we did with our policy.
But it's a recommendation.
It's a recommendation, right, it's non-binding.
All of it is not binding.
Are there other questions or comments?
I just have a concern, I continue to have a concern about including studies in our guidances. I think that, you know, I don't think we need to prove to the municipalities or why we're putting in here what we're putting in here because they are guidances. I just have a real concern that we're sort of telling them that what studies are out there and what studies aren't out there. And I think, again, as I said before, we can probably find researchers that will find studies to go against some of the studies that we are putting in here. So my request would be that we pass this without studies, but if people feel they need to, then I'm willing to vote against it on my own.
I really, truly promise that I don't have any agenda as to what it should say with regard to the research. I think whatever the research says should be characterized here. But we are a very capable agency. We have a research department, we have a research agenda. If we can't put forth 2 paragraphs, you know, that just characterize what the research says on an issue, I think that's a much bigger problem.
No, I appreciate that. I have, you know, I see these guidances as a way for people to be able to read them and get some very concise answers and questions to their questions. I just think that when we start including studies, it changes the scope of a document. But like I said, that's up to the person.
It's also just that we did get so much feedback from, on an ongoing basis from people in municipal governments or people who are trying to make these decisions. And they have so many other things to do, and they don't have time themselves to go back and like do, you know, a review of studies. So I feel like if we, as a trusted authority, can just make a summary for them, that information would be helpful.
I can appreciate the concern about, you know, including some studies and not including other studies. Can I maybe suggest that if we agree to keep these studies in there, that because as with all of our guidances, these are, you know, intended to be living, breathing documents, that if there are other studies that have additional information that are, you know, that's brought to bear, particularly that's relevant to Massachusetts and the Commonwealth, as Julie, you know, gets underway with the research agenda, and we're sort of developing that we could include that information as another resource for municipalities that might be reviewing this document as a way to sort of move forward with it.
So are you suggesting saying something in the document itself that will update these studies or add additional studies as they become available and relevant?
I think that might be helpful, and then actually, you know, doing it as we move forward.
Yeah, I guess I would just characterize it though as not necessarily adding every additional study, but updating it and making sure that it's current based on the most updated information.
I mean, my real concern here is reflecting information that's relevant to our state. And so I really want, for the studies that we're referring to, would be most comfortable to be referring, if we're going to refer to any studies, there should be studies that are relevant to our state and to our economy, right? And so that's kind of what I guess I'm getting at here. I have one more comment.
Please.
I'm a little leery of using the verb discourage, and this might be qualified as wordsmithing, but it feels a little, it just feels like a little punitive to me. So could we say, we encourage municipalities to carefully consider whether separation requirements are necessary?
Sure.
Thank you.
Are there any comments? Commissioner Vaughn?
No, thank you.
So, are you, well, I guess where we're at is there are 2 recommended edits, without being explicit. One is the language change that Commissioner McBride just suggested. Second is the language about including future studies, also suggested by Commissioner McBride.
Don't forget mine.
Don't forget yours and.
Use of the string site.
Yeah.
And then Commissioner McBride, sorry, were you suggesting that we say in the document something about keeping it updated, or just that?
That's right, I asked her, I thought the answer was yes, that was your suggestion, but I'm not sure. Which one?
I mean, it might be helpful to call it out and say that that's the case. Well, it does, I think, just that people know.
I had said, where we say current studies do not show any evidence that medical marijuana dispensaries increase youth access. I just asked that we cite the study.
Oh, yeah, okay. Okay. I'm sorry, I apologize. So are you suggesting we include the language that we will add studies? And you can, okay. I guess unless there are further comments, I'd like to add for a motion to approve the guidance based upon the edits that were just agreed to.
So moved.
Can I have a second, please? Commissioner, let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner McBride. All in favor?
Aye.
Commissioner Pennell?
Aye.
All opposed?
Nay.
Let the record show that the commission approved the release or this guidance by a vote of 4-1, with Commissioner Flanagan voting aye and nay, and Commissioner McBride
I would like to suggest that we take a 10-minute break, so it's 3:20.
There's not a question really in my mind as to whether that can be provided for in a host community agreement. I think that it's a term that can be negotiated in a host community agreement. So.
With the caveats of proportionality and documentation.
Well, and but that we just talked about.
No, that.
Right, but we just talked about, right, that it complies with the applicable
Mhm.
law. So, you know, this isn't to kind of come in and to say, you know, this trumps everything that exists prior to it. These have to work together, they have to dovetail, and this is, you know, one distinct area where that is provided for.
Could I add one
Sure.
quick thing? I think attorneys in particular that have experience in this area would be a wonderful addition to our social equity RFQ responses. So I think one of the things, to the extent we have people who can communicate to the world that this is a group that we really would love to see responses by people who are familiar with appearing before municipalities and can help our applicants understand that world and be a part of that program. I would really encourage them to apply, and the deadline is September 7th.
Unrelated on the second question, I just want to go back to this issue of flat fees. And I just want to, I'm not sure whether I heard you correctly or whether you covered it or not. You did mention some notion of reconciliation if it turns out that the flat fee exceeds with 3% of gross revenue, because I understand you can't forecast that up front. What's the language you're proposing, and is it a requirement or a suggestion?
It's not a requirement, it's a suggestion. I wouldn't even propose language on it necessarily.
Why not?
Well, because I'm not sure that, you know, I'm not sure that it's appropriate for us to do that. I guess I'm open to other commissioners' views on, you know, all of the language that's included in here in the specific terms is suggested language. I throw out there, you know, with regards to the flat fee that I guess it's, you know, possible that there could be a provision in there that could be a clawback provision, but I mean, truthfully, I'm not confident enough in my analysis to say that we should enshrine that in this quite yet.
Well, my perspective, and it's a non-legal perspective, my perspective is that if the law says it can't exceed 3% and the flat fee in retrospect turns out to be in excess of 3%, then it's a violation. Maybe that's the wrong word, and again, I'm not trying to, think about this as a business argument, not a legal argument.
No.
Don't think about the legal language or anything, but just the idea that if it turns out that, you know, that there's been a misforecast, which I think is gonna be likely of what the revenue stream is gonna look like, it could exceed. Now, it also could work the other way, it could, you know, could be less than 3%, but if it exceeds 3%, isn't it at least contrary to the spirit of what we're talking about here?
Mr. Johnson,
Sure.
I don't actually think that there's a need to suggest language. I think I trust the contractors to be intelligent enough, the people making the contract, that if they can come up with an agreement, they can come up with a way to say that the flat fee won't exceed 3% and what they would do if that happened.
I guess I'll reserve judgment when we see some of these contracts, but that's fair. Okay.
If we see them.
Well, we're gonna get to that shortly, I promise you. So I guess what we're saying then is that there's no suggested changes other than the ones that Commissioner Tuttle made to the suggested edits by Commissioner McBride. We'll come back to how the process for finalizing the document in a little bit, but I think with respect to the edits that you suggested, I think the conversation is probably concluded. So then let's move into other comments, questions, or suggestions on this topic. Commissioner McBride, please.
Ready, Commissioner Tuttle?
I'm sorry, yeah, Commissioner Tuttle, I'm sorry. I did. No, you're not off the hook yet, Commissioner McBride.
You're in his head.
You are in my head. Go ahead, Commissioner Tuttle, I apologize.
No problem. So I want to thank everybody who sent in the feedback. I read all of it. I thought it was really thoughtful and valuable. And I want to thank everyone who took the time out of their obligation to send it to us.
I apologize, could you turn your microphone on?
Was it off? Oh, thank you.
Thank you.
Colin, right?
Yes,
Thank you,
ma'am.
Colin. So I just said thank you for the feedback. I think that it's clear looking at the feedback that this is an issue that is not going away. and that we should consider, just like we did last week when we looked at what was happening, or last meeting, when we looked at what was happening with the econ empowerment applicants, we said maybe we should evaluate what's happening today and revisit it. I think we should do the same thing with community host agreements. I noticed in the comments that there were 2 comments that said they felt that there was unsubstantiated, unfair perception that municipalities were at fault to blame. So I want to reiterate what I said at our last meeting and afterwards, which is that I believe the vast majority of municipalities are acting in good faith and trying to really implement what their constituents want. But I also think, I know that there is evidence that there are some municipalities that are going beyond what's in this guidance, and I think in the interest of providing a fair and consistent landscape to all of the applicants, that we should talk about looking at community host agreements. So in the interest of precision and clarity, I typed out a motion. The essence of this motion is that an applicant's host community agreement will be reviewed for compliance with the law before a final license can be issued. So I'll read through the motion and then make a couple of notes with the feedback that we received in mind. So the motion is that the commission will require applicants to submit signed host community agreements and will review them as part of its licensing process. The scope of review will be limited to ensuring that licensees are compliant with MGL Chapter 94G, Section 3D, which is noted, including that the community impact fee is, and the next 3 items are all directly from the law. They're also in the guidance we just reviewed. 1, reasonably related to the costs imposed upon the municipality by the operation of the marijuana establishment or medical marijuana treatment center. 2, not more than 3% of the gross sales of the marijuana establishment or medical marijuana treatment center. And 3, limited to a term of 5 years. And that the host community agreement includes all stipulations of responsibilities between the host community and the marijuana establishment or medical marijuana treatment center. Again, all lifted directly from the law. So the first question is, what is the scope of our review? That came up a lot in the feedback. It would be limited to Section 3D, and particularly these 4 items. The second question that came up is, what is our authority to pass such a policy? So under MGL Chapter 94G, Section 4A, the Commission has all of the powers necessary or convenient to carry out and effectuate its purposes, including the power to require an applicant for licensure to apply for such licensure and approve or disapprove any application, determine which applicants shall be awarded licenses, and deny an application or limit, condition, restrict, revoke, or suspend a license. Going further, with regard specifically to our ability to ask for a community host agreement and check it for compliance with the law before issuing a final license, our regulations state the Commission may conduct inspections of the facilities as well as review all written materials required in accordance with 935 CMR 500. An inspection or other investigation may be made prior to the issuance of a license or renewal of registration. Upon completion of all inspections required by the Commission, a marijuana establishment is eligible for a final license. With regard to the questions about our authority to interfere with a private contract, we are not interfering with the private contract. We are merely checking for its existence and doing a limited review for compliance with the law in the exact same way that we check leases, for example, to ensure that there is a property interest. No one has ever raised a question as to whether we are interfering in the contract between a landlord and a renter, because we are not. And then the last question that I expected would come up based on the feedback is, what is the process? I specifically did not include a process because I would leave that in the capable hands of our licensing and investigation team that already makes these decisions. But my suggestion would be a very similar process, again, to where we check a lease to determine that there is a property interest. So in this case, potentially we could have a checklist of these 4 items. But again, I would leave that up to our staff.
my main concern is that we aren't specifying the process. And it seems like, to me, my read of the law is that the process for enforcement that we have is going to be to deny the license or refuse to approve it until such time as we receive a host community agreement that we deem to be compliant, which is probably the most likely thing we would end up having to do, because I think that's what the limit of our authority. And I'm really concerned that, to the extent that the concern is that municipalities are asking for more than is appropriate, it's basically going to hurt the applicant more than anything. And so that would be my first concern. My second concern is going to be, we are looking at the fall town meeting season. This is a critical time. I think it's been widely reported that there are a number of municipalities that are looking to take action and decide how they're going to approach whether or not to allow marijuana at all for adult use in their communities. And I am concerned that if we make this even more complicated than it is by inserting ourselves in this, and I just don't think it's as easy as our lease review, I think it is more complicated, that we may deter communities that were considering allowing marijuana for adult use in their community, that it may be an additional reason for them to swing towards not allowing it. So my two concerns are, I think what we're authorized to do doesn't help the people we're trying to help, and then I'm worried about the effect it will have on the overall rest of the town meeting season.
Thank you. So on the first point, yes, I agree that denying the application would be what we have the authority to do. I actually don't have a problem with that. To the extent that this has been represented as only the municipality's problem, I guess I would emphasize that if there is a contract that is being signed that goes beyond what's in the law, there are two parties to that contract. And if you are an applicant that is making a payment that you are not lawfully allowed to make in exchange for some kind of special treatment, I think that's a problem, and I don't think that your license should move forward. And secondly, it's not really our call to make, I don't think, as to whether we're hurting the applicant. I mean, if that was the issue, then we shouldn't ask for a lease because there are applicants that are having trouble finding a lease, but we have to deny it, even though that hurts them if they don't have a property with their application. So I see this as similar. They have to have a community host agreement that is compliant with the law in order to operate. On the second issue, in terms of the timing, I think it is critical that we address this now because we have not issued a final license yet. If we were to issue a final license without inspecting a community host agreement, and we decided later and changed our minds, we would be treating applicants differently.
Give both people a chance. Commissioner Brown.
I guess I care about hurting applicants, but the thing that's more concerning to me about the action that would really be, I think, our only action, and I'll talk further, I guess, about why I think this is probably our only action, but the denial of the license, it hurts the applicant. I think it penalizes, them in potentially a way that definitely holds up the application. But it also opens us up, because it's an administrative action, it opens us up to legal processes and to being sued. And I don't particularly want for us to be sued, although
good luck.
may be inevitable. So I guess that's my first comment. I mean, the second comment is that it's not lost on me that the reason that we're engaging in this conversation is because there has been seemingly a bottleneck where applications are not getting done in a timely fashion because of these negotiations, and that the suggested solution to that is to add an additional bureaucratic process onto a process that is already being complained about, as being slow. So I'm a little, I guess I'm concerned that, we're proposing a process here that fundamentally is, likely to penalize the applicant. And that in addition to that, and this is, I guess, kind of like where I started, I don't quite understand what the authority is that we would have to actually effectuate a change in the negotiated host community agreement. And I'm curious as to what people think our authority is to tell municipalities what to do. And then, I guess, kind of the subset thought there is, I'm not certain that we have any authority to review host community agreements based on the statute as it is written. And, we can have a discussion about what the intent was there, which I'm happy to engage in, but when I read what our authority is, and I read that very extensive list that's included in sections 4 and 4A1/2, there's a lot of very explicit requirements of things that we have to do and regulations that we have to promulgate, and there's no explicit authorization there for us to perform a review. And so I think that we are going to be casting it out a little bit to find legal authority that forms the basis for us to be able to engage in that activity in the first place. So I guess there are a couple pieces there. I question our legal authority, and then I question actually what the implications would be.
Is the staff recommendation, or the staff recommendations on the 7 completed applications. So let's just jump right into it. The first one is Pharmacannis, Massachusetts, MRN 281252 retail. Mr. Executive Director.
Sure, thank you, Mr. Chairman. As you indicated, this is an application for Pharmacannis, Massachusetts, incorporated, located on 112 Main Street, Wareham. It's a retail application. They have not submitted at this time any other applications for a marijuana establishment. The individuals tied to the license or identified in the various roles are Michelle Stormo, Teddy Scott, Stephen Schuler, Michael Cottle, Kimberly Evans, Jeremy Hunter, Nora Scott, and Daniel Tierney. The parent company is Pharmacannis, LLC, and they have achieved an RMD priority status. They are an existing RMD that secured their provisional certificate of registration for dispensing in Wareham, and they intend for this business to be located with that RMD. Their host community agreement was executed on April 26th, and certification has been provided to that effect. The community outreach meeting was held on March 29th. It was published at least 7 days prior to the Wareham Courier. They certified notice to the municipality as well as any butters. They certified their compliance with the meeting requirements. There were no objections identified to the commission. We received a response from Wareham on July 19th stating that the applicant is in compliance with all local ordinances and bylaws. As far as their summary for positive impact, in areas of disproportionate impact, they intend to do the following. Forge relationships with local groups fighting addiction, make donations to groups, specifically Wareham Fighting Addiction, then to continue their operations, and lastly, coordinating efforts with Wareham to positively affect problematic and underfunded issues facing the community on an ongoing basis. There were no concerns that were identified from the background check on individuals associated with the application. Similarly, no concerns raised during the background check on entities associated with the application. There were disclosures of past civil and criminal actions, where none of those issues presented suitability issues. The applicant did not disclose any occupational license issues. They do have business interests in other jurisdictions. Pharmacannis, LLC is the parent company, as well as individuals associated with the application do have marijuana-related business interests in the following jurisdictions: Illinois, New York, Maryland, Illinois, New York, Maryland, and Pennsylvania. They have provided certification of a certificate of good standing from the Secretary of the Commonwealth, as well as the Department of Revenue. As far as their management and operations profile, they intend to be operational within 2 months of being issued a provisional license. The proposed hours, again, this is retail, are 10 a.m. to 7 p.m. They provided compliance with submitting summaries of the following plans, policies and procedures: security plan, prevention and diversion plan, storage of marijuana plan, transportation plan, inventory procedures, quality control and testing procedures, personnel procedures, dispensing procedures, record keeping procedures, maintenance of financial records policy, and diversity plan. The applicant is fully compliant with submitting all these summaries, and those summaries have been deemed or determined to be substantially compliant with all the requirements of our regulations. Of course, we'll review full compliance during our inspection process, which will be required before a final license is issued. As far as the diversity plan, their applicant's plan outlines its goals and includes the following. The applicant plans to actively recruit disadvantaged individuals, plans to contract with disadvantaged businesses, including those owned by women, veterans, minorities, and disabled individuals. And lastly, the applicant plans to conduct diversity training for its employees. Because this is a retail license, there's no cultivation plan or summary products to be produced. However, their plan for obtaining marijuana or marijuana products is that they secure 2 wholesale agreements to purchase marijuana from other licensed RMDs for its medical use operations, and plans to continue with these agreements for the adult use operation. This commission staff has recommended issuing a provisional license with the following conditions: that the final license is subject to the required individual successfully completing a fingerprint-based background check of state and national criminal history databases. Final license is subject to certification that the applicant remains in compliance with DPH regulations. Final license is subject to inspection and audit to ascertain compliance with the requirements listed in our regulations. Final license is subject to inspection and audit to ascertain that its facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. The applicant shall cooperate with and provide information to the Commission's investigators, agents, and employees upon request. And lastly, the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, its suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. We certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and its suitability for licensure. Accordingly, the applicant is recommended for provisional licensure with the previously mentioned conditions.
Thank you. Are there questions or comments? Then can I have a motion to approve the staff recommendation, please? And second, please. Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor? Let the record show Commissioner I.N.S.A. approved the staff recommendation for provisional licensure of Pharmacannis, Massachusetts, MRN 281252. Thank you. Next on the agenda is M3 Ventures Incorporated, MCM 281446, Tier 2 Indoor-Cultivation.
Thank you, Mr. Chairman. As you indicated, this is an application for M3 Ventures. The location of the establishment is 9 Collins Avenue, Plymouth, Mass. No relation. The license sought is a cultivation Tier 2 indoor, which authorizes cultivation up to 10,000 square feet. The applicant has also submitted applications for its retail and product manufacturing licenses, which are pending next. The individuals in their role at the establishment are the following: Krista Angner, Jonathan Hurley, Drexler Topping, James McCarrow, Kevin O'Reilly, Joseph Larrabee, Doug Andrew, Keith Dibbetts, and Elizabeth Nolan. The parent capital resource entity included in the application is Triple M Management Company, LLC. They have secured their R&D priority status through their final certificate of registration for cultivation, processing, and dispensing. This is a proposed co-located adult use and R&D plant. A host community agreement was executed on April 24th, and certification to that effect has been provided. A community outreach meeting was held on March 21st. Notice was published in the Old Colony Memorial. The applicant certified notice the municipality as well as butters and certified their compliance with the meeting requirements. There were no objections raised to the commission. We did receive a response from the municipality on July 13th, stating that the applicant is in compliance with all local ordinances and bylaws. Their plan to positively impact areas of disproportionate impact includes plans to communicate with veteran groups and local workforce development boards in Abington, Braintree, Brockton, and Taunton to identify and recruit potential employees, and plans to hold job fairs and give hiring preference to the individuals from the previously mentioned municipalities. There were no concerns raised during the background check on individuals associated with the application. Similarly, no concerns raised during the background check on entities associated with the application. There were no disclosures of any past civil or criminal actions, and no disclosures of any occupational license issues. Similarly, no disclosures of any business interest of the jurisdiction. There was a submission of a certificate of compliance from the Secretary of the Commonwealth as well as the Department of Revenue. The proposed timeline to become operational is within 7 weeks of being issued a provisional license. The proposed hours are Monday through Sunday, 24 hours a day. The applicant was compliant with submitting summaries of the following plans and procedures: a security plan, prevention and conversion plan, storage of marijuana plan, transportation plan, inventory procedures, quality control and testing procedures, personnel procedures, dispensing procedures, record keeping procedures, maintenance of financial records policy, and diversity plan. They're fully compliant with submitting all the summaries of their operations manual. All summaries were determined to be substantially compliant with our regulations and full compliance we reviewed during our inspections and will be required before final license is issued. The diversity plan includes the following. The applicant plans to work with local workforce groups to ensure the representation of underrepresented marginalized groups in its applicant pools. The applicant plans to advertise job positions without imposing unnecessary educational requirements. The applicant will implement a policy called bridging positions, which will enable marginalized groups to gain qualifications and experiences needed to advance within the company and the industry. Their cultivation plan included submitting an operations manual that systematically explained the techniques and processes utilized for cultivation throughout the propagation of vegetative and flowering stages. There's no summary of products to be produced and sold, and no plan for obtaining marijuana products as it's a cultivation license. Commission staff recommends issuing a provisional license with the following conditions. The final license is subject to certification that the applicant remains in compliance with DPH regulations. The final license is subject to inspection and audit to ascertain compliance with the requirements listed in our regulations. The final license is subject to inspection and audit to ascertain that its facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. The applicant shall cooperate with and provide information to the Commission's investigators, agents, and employees upon request. And lastly, the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. Commission staff certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure. Accordingly, the applicant is recommended for provisional licensure with the previously mentioned conditions.
Thank you. Are there any questions or comments? Commissioner Tao?
Just one comment that to the extent the next two applications have the same information, it's okay with me if you don't want to read it out.
That's one.
Oh, come on.
I've got time.
Yeah, fair enough. Other than that, any questions or comments? And can I have a motion to approve the staff recommendation? And a second, please. Let the record show Commissioner Doyle made a motion to approve, second by Commissioner McBride. All in favor? Aye. Let the record show the Commission unanimously approved the recommendation of staff with respect to M3 Ventures MCM 281446 Tier 2 individual cultivation. Thank you. I'm just going to ask, I just need to grab some water.
Sure. Hold on one second. I didn't say you could get up.
I'm saucy like that. Again, loss of control.
Well, that would imply that at some point I ever had control.
Trying to make it sound better.
Thank you.
Let's continue. M3 Ventures Incorporated, MRM 281290 retail, and I support Commissioner Powell's suggestion.
The floor is mine, Mr. Chairman.
It is. You can do with it as you see fit.
I should also mention that the conditions listed on the last application are not different. The fingerprint criteria was not included as moving forward. Fingerprinting is operational, functional, and incorporated into our background check, so it'll no longer need to be a condition on the provision status. As you indicated, this is M3 Ventures. This is the retail application. The location is proposed as 9 Collins Ave in Plymouth. They've also applied for their cultivation and product manufacturing licenses. The individuals are the same as listed previously. Similarly, with capital resources is the same. They have secured their R&D priority status. Post-community agreement was executed on April 24th. The certification was provided. Community outreach meeting was also held on March 21st, as previously mentioned. We received certification from the municipality on July 13th. The summary positively, plan to positively impact the areas of disproportionate impact is the same as previously mentioned. No concerns raised during the background check on individuals, entities, no disclosures of any past civil or criminal actions, no disclosures of any occupational issues, no disclosures of any business interests or jurisdictions. The same certificate of good standing has been submitted. As far as management and operations profile, similarly, I plan to be operational within 7 weeks. The proposed hours are Monday through Sunday, 10 a.m. to 8 p.m. The plans that were submitted previously are also included in this application. Summary diversity plan is the same as previously mentioned. Because it's retail, there's no cultivation and no production plan. That's it. The plan for obtaining marijuana products is that the applicant is vertically integrated as an R&D, that they're applying for adult use cultivation product manufacturing licenses. If necessary, the applicant plans to obtain an inventory waiver from DPH to supply its initial retail operations. The commission staff is recommending a provisional license with the following conditions. The final license is subject to the certification that the applicant remains in compliance with DPH regulations. The final license is subject to inspection and audit to ascertain compliance with the requirements listed in our regulations. Final license is subject to inspection and audit to ascertain that facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. The applicant shall cooperate with and provide information to the commission's investigators, agents, and employees upon request. And lastly, the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation was based on the applicant's demonstrating compliance with laws and regulations of the Commonwealth and suitability for licensure upon the evaluation of the thoroughness of the applicant's responses to the required criteria. We certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure, and accordingly, the applicant is recommended for provisional license with previously mentioned conditions.
Thank you. Any questions? Can I have a motion to approve staff recommendation, please?
Second.
Is there a second? Thank you. Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Tuttle. All in favor?
Aye.
Let the record show the commission unanimously approved the staff recommendation with respect to M3 Ventures MRN 281290 for retail. Thank you. Next is M3 Ventures Incorporated MPN 281346 for product manufacturing.
Mr. Chairman, this is the same applicant, same location in Plymouth. The license slot is a product manufacturing license. The individuals involved are the same. The capital resource entity is the same. And again, they've secured their R&D status. This is because it's the same location, it's intended to be co-located. The host community agreement was executed on April 24th. Community outreach meeting held on March 21st. We received no objections from the community and received a response from the municipality on July 13th. The summary of plan to positively impact areas of disproportionate impact is the same. No concerns raised during the background check on individuals or entities, and no disclosure of any past civil or criminal actions, no disclosure of any occupational license issues, and no disclosure of any business interests in other jurisdictions. The same certificate of good standing was submitted from the Secretary of the Commonwealth as well as the Department of Revenue, and they would plan to be operational within 7 weeks for being issued a provisional license. The proposed hours are Monday through Sunday, 24 hours a day. The plans and summaries submitted were the same, and their diversity plan presented was the same as the previous applications. There's no cultivation plan, but their summary of products to be produced or sold includes the following: pre-rolled products, hash powder, ethanol, honey oil, gel capsules, solids, sublingual sprays, vaporizer pens, and tinctures. There's not a retail license, so there's no plan to obtain marijuana products related to the retail license. The commission staff recommends issuing a provisional license with the following conditions. Final license is subject to certification the applicant remains in compliance with DPH regulations. Final license is subject to inspection and audit to ascertain compliance with our regulations. Final license is subject to inspection and audit to ascertain that its facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. And the applicant shall cooperate with and provide information to the commission's investigators, agents, and employees upon request. And lastly, that the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth and suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. Commission staff certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated its compliance with the laws and regulations of the Commonwealth and its suitability for licensure, and accordingly, the applicant is recommended for provisional license with the previously mentioned conditions.
Thank you. Any questions? Can I have a motion to approve the staff recommendation, please? Let the record show Commissioner McBride made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show Commissioner I.N.S.A. approved staff recommendation with respect to M3 Ventures, MPN 281346 product manufacturer. Thank you. Next is I.N.S.A. Incorporated, MCM 281268, Tier 7 Indoor-Cultivation. Mr. Executive Director.
Thank you, Mr. Chairman. As you indicated, the applicant is I.N.S.A. Incorporated. The proposed location is 122 Pleasant Street, East Hampton. The license sought is a cultivation license, a Tier 7 indoor, which authorizes up to 60,000 square feet of cultivation, canopy, excuse me. The applicant has also applied for a retail and product manufacturing license, which will be considered later. The individuals listed in their role in the business include the following: Peter Gallagher, Patrick Gottschalk, Steve Riley, Mark Zatirka, Brian Hammond, John Janey, and Ian Kelly. Entity associated with the application is GPM2 LLC, which provides capital resources. It's an R&D priority status, as they obtain their final certificate of registration for cultivation, processing, and dispensing. This is a proposed co-located facility in East Hampton. Host community agreement was executed on April 24th, 2018, and certification has been provided to that effect. The community outreach meeting was held on March 30th, and notice was published in at least 7 days prior to the Daily Hampshire Gazette. There were no objections raised to the commission by the municipality. In fact, we received a response on July 27th, stating that the applicant is in compliance with all local ordinances and bylaws. Their plan to positively impact the areas of disproportionate impact include providing additional employment opportunities for the residents of Springfield, engaging with local community groups to educate the public on responsible consumption of cannabis and the prevention of diversion to individuals under 21, and providing charitable donations to community groups and contributing employee time to local events. There were no concerns raised during the background check on individuals or entities associated with the application. There were disclosures, however, related to any past civil or criminal actions, but none of those disclosures presented suitability issues. Applicant did not disclose any occupational license issues and no disclosures of any business interests in other jurisdictions. They did submit a certificate of good standing with the Secretary of the Commonwealth as well as the Department of Revenue. The applicant proposes to be operational within 1 month of being issued a provisional license. Proposed hours are Monday through Sunday, 8 a.m. to 5 p.m. And they submitted the the summaries of the following plans, procedures, and policies. As previously mentioned, I won't read the entire list again. Those summaries, though, are fully compliant with, they are fully compliant with submitting all of those summaries, and those summaries have been determined to be substantially compliant with our regulations. We will ensure full compliance during our inspections, and we will be required before a final license is issued. Their plan for diversity plan, a summary diversity plan includes engaging in diversity-oriented outreach for employment purposes, specifically by working with agencies that represent minorities. A plan to employ a diversity officer to conduct diversity training for its operation, and planning to conduct manual analyses to ensure diversity programs are working effectively. Their cultivation plan included submitting a summary that systematically explains the various techniques and processes utilized for cultivation throughout the cloning, vegetative, flowering, and harvesting stages. There's no summary or plan, no summary of products to be produced, no plan for obtaining marijuana as it's a cultivation license. Commission staff recommends issuing a provisional license with the following conditions. Final license is subject to certification that the applicant remains in compliance with EPA's regulations. Final license is subject to inspection and audit to ascertain compliance with our regulations. Final license is subject to inspection and audit to ascertain that facilities are compliant with all applicable state, local codes, bylaws, ordinances, and regulations. And the applicant shall cooperate with and provide information to commission's investigators, agents, employees upon request. And lastly, the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, its suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. Commission staff certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and its suitability for licensure. Accordingly, the applicant is recommended for provisional license with the previously mentioned conditions.
Thank you. Any questions? May I have a motion to approve staff recommendation?
So moved.
Let the record show Commissioner Doyle made the motion to approve, seconded by Commissioner Flanagan. All in favor? Let the record show Commissioner unanimously approved the recommendation of staff with respect to I.N.S.A. MCM 281-268 through 7 Indoor-Cultivation. Thank you. Next is I.N.S.A. Incorporated MPN 281-426 product manufacturer. Mr. Executive Director.
Thank you, Mr. Chairman. This is the same entity as previously referenced. The location is also 122 Pleasant Street, East Hampton. This is their product manufacturing license. The same individuals are listed on the application. The same same entity associated with it providing capital resources, and they have secured their R&D priority status. This too is planned to be a co-located establishment with a host community agreement that was executed on April 24th, and a community outreach meeting that was held on March 30th. We did receive a response from the municipality on July 27th, stating that the applicant is in compliance with all local ordinances and bylaws. Their summary of a plan to positively impact areas of disproportionate impact is the same. On the background check, there were no issues raised during the background check on individuals or entities associated with the application. There were disclosures of past civil and criminal actions, however they do not present suitability issues. The applicant did not disclose any occupational license issues or any business interests in their jurisdictions. They did submit a certificate of good standing from both the Secretary of the Commonwealth as well as the Department of Revenue. Their plan is to be operational within 1 month of being issued a provisional license. Their proposed hours are Monday through Sunday, 8 a.m. to 11 p.m. They submitted the same plans and summaries as required, which will be reviewed during our inspection process and required before the final license is issued. Their diversity plan was the same as previously mentioned, and their summary of products to be produced includes the following: chocolate bars, lozenges, fruit chew, beverages, mints, brownies, wax, sugar, shatter, crumble, vaporizers, tinctures, capsules, and reusable cartridges. The Commission staff recommends issuing a provisional license with the following conditions. Final license is subject to certification that the applicant remains in compliance with DPH regulations. Final license is subject to inspection and audit to ascertain compliance with our regulations. Final license is subject to inspection and audit to ascertain that facilities are compliant with all applicable state and local codes, bylaws, ordinances, and regulations. The applicant shall cooperate with and provide information to Commission's investigators, agents, and employees upon request. And lastly, that the provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, its suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. Commission staff certifies that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and its suitability for licensure, and accordingly, the applicant is recommended for a provisional license with the previously mentioned conditions.
Thank you. Any questions? And may I have a motion, please, to approve the staff recommendation?
So moved. Second.
Let the record show Commissioner Flanagan made the motion to approve, seconded by Commissioner Doyle. All in favor?
Aye.
Let the record show the Commission unanimously approved the staff recommendation with respect to I.N.S.A. MPN 281-426 product manufacturer. Thank you. Next is I.N.S.A. Incorporated MRN 281-680 retail. Mr. Executive Director.
Thank you, Mr. Chairman. It's the same entity as previously referenced, the same location in East Hampton. This is their retail license. The same individuals are involved with the same required entity involved as well. They have secured their R&D priority status. This is also a proposed co-located facility in East Hampton. The host community agreement was executed on April 24th. The community outreach meeting was held on March 30th. We received a response from East Hampton on July 27th, stating that the applicant is in compliance with all local ordinances and bylaws. The plan to positively impact areas of disproportionate impact is the same. There were no issues raised during the background check on individuals or entities associated with the application. There were disclosures of past civil and criminal actions. However, none of those disclosures present suitability issues. The applicant did not disclose any occupational license issues, as well as no disclosures of any business interests in the jurisdictions. We did receive a certificate of good standing from the Secretary of the Commonwealth as well as the Department of Revenue. They proposed to be operational within 1 month of being issued a provisional license. The proposed hours are Monday through Sunday, 10 a.m. to 8 p.m. They submitted summaries of the required plans, and we will inspect during our inspection process. Those plans and review will be required before a final license is issued. The diversity plan was the same as previously mentioned. The plan for obtaining marijuana products includes The fact that they are vertically integrated R&D that is applying for adult use cultivation and product manufacturing licenses. If necessary, the applicant plans to contract with other licensed cultivators and producers to obtain marijuana products. The commission staff recommends issuing a provisional license with the following conditions. The final license is subject to certification if the applicant remains in compliance with EPH regulations. Final license is subject to inspection and audit to ascertain compliance with our regulations. Final license is subject to inspection and audit to ascertain that its facilities are complying with all applicable state, local codes, bylaws, ordinances, and regulations. That the applicant shall cooperate with and provide information to commission's investigators, agents, and employees upon request. And finally, that a provisional license is subject to the payment of the appropriate license fee pursuant to our regulations. This recommendation is based on the applicant's demonstrated compliance with the laws and regulations of the Commonwealth, the suitability for licensure, and upon the evaluation of the thoroughness of the applicant's responses to the required criteria. We certify that a due diligence review of the application has been performed, and as of this date, the applicant has demonstrated compliance with the laws and regulations of the Commonwealth and its suitability for licensure. Accordingly, the applicant is recommended for provisional licensure, subject to the previously mentioned conditions.
Thank you. Any questions? Can I have a motion to approve staff recommendation, please?
So moved. Second.
The record show Commissioner Flanagan made a motion to approve, seconded by Commissioner Doyle. All in favor? Let the record show the Commission unanimously approved the recommendation of staff with respect to I.N.S.A. MRN 281680 for retail. That is it for the recommendation on licenses. I just want to again take the opportunity to thank the staff for the work involved in reviewing these in a timely and efficient manner. So very much appreciated, and unfortunately here to inform you that there are more to come.
Mr. Chairman, as I indicated before, I think it's just important to remind folks, we do treat these as individual applications.
Right.
And our review is individual per application. So
That's a good point. Okay. Greatly appreciated. There is no additional business that I did not anticipate.
Actually, Mr. Chairman,
Yes.
I wanted to make a request that on the next agenda,
Yes.
next meeting, that we begin to engage in a conversation about the delegation of responsibilities and decision-making to staff. I think we're kind of reaching a critical juncture right now where we are getting questions from applicants about how they're kind of the nuances of the regulations
Sure.
and how to interpret them. And I want to make sure that we're efficiently kind of moving through our processes and allowing our licensing staff in particular to answer those questions.
And that's a great idea.
So-
I'll make sure that that's on the agenda as I work with the executive director and our chief of staff.
Thank you.
Sure. Anything else? Okay, the next meeting, let me just look through the back of the presentation so I know exactly where it is and when it is. Oh, one too far. So Thursday, August 23rd, 1 p.m., and we're still at the Gaming Commission. My thanks, by the way, I don't know that I said that at the beginning. My thanks to the Gaming Commission for allowing us to use their facilities.